appeal without the certified copy of the order, my lord. Judgment.
What is the urgency?
Urgency that the contempt proceeding has been drawn up, my lord. Rule has been issued.
When did you apply for certified copy?
My lord, it has been applied, my lord, day before yesterday, my lord.
When is the
My
contempt?
lord, since the contempt is pending in the principal bench and the original writ petition has been tagged with the contempt petition. That is the reason why I am unable to get the certified copy.
Leave granted.
Grateful.
Yes, call the list.
I wanted to mention, my lord, in respect of today's item, list, my lord, 82, my lord. Suit for my lord, eviction, my lord. I have the tenant, my lord. There is a date fixed before the landed court below execution, my lord.
On?
Execution of police report, my lord. My lord.
Second, key mention.
My other side, Mr. Chakriti Mishra is appearing, my senior friend, but I have already intimated to him. I have mentioned, but I have given notice to him also, my lord. I'll fix.
Second, I mention. When is your execution date?
But tomorrow it will take fixed.
How it can be taken up today?
It can be fixed on Monday, my lord. Then I intimated the court that one date, only given 2 days time before the court. Fixed the date, my lord.
মঙ্গলবার নিয়ে এটাকে মঙ্গলবার দিনকে দিয়ে দিন টিউসডে
My lord.
May mention the matter.
টিউসডে এটা 82 না জাস্ট ওয়ান মিনিট কার্তিক 82 এটা কি অর্ডার এই ম্যাটারটাকে অর্ডার 41 করে একটু উপরে রেখে দিই একটু উপরে রেখে ইউ ইন্টিমেট ইওর আদার্স
My lord.
it will be a fairly at the top. But if you get the adjournment, what is your problem?
My lord. So, my date, many date fixed. I'm taking that matter is pending. I even intimated the court, but there is no. Otherwise, my lord, police, my lord, there is a date fixed for police help, my lord. Otherwise, my lord, only.
All right,
This
let
time-
it appear, let us see. Yes,
My lord.
In this cause list is item number 143. It's a bail application, bail in connection with the appeal matter.
huh. So it
That
was
matter-
called on, sir.
that-
First day it was called on, we disposed of one matter, you did not appear.
143. I don't know.
143.
That it may be called for. The paper book. of the
143 is criminal appeal.
Criminal appeal, along with the CRAN application, CRAN 2 is bail in connection with appeal.
Appeal has been admitted.
Appeal has been admitted,
Paper books ready.
all are ready, Lordship.
So you did not earlier move cancellation for bail?
Lordship, it's pending.
Pending, I don't know, your application for bail,
Bail.
connection with appeal, you could have mentioned, it could have come at the top.
Lordship, that's why I'm mentioning.
Wait, let us see how we proceed. Eta ki, eta CRAN ache. Who is your other side?
It is, Cecil studies
140,
3.
Mr. Chakraborty, you're there. You're there.
Bail in connection with appeal.
Appeal hearing আছে, ওটা কি bail in connection with
Bail in connection with appeal. Bail connection with appeal. এটা আছে এখানে।
আচ্ছা, it will come under the heading bail in connection with appeal. Then it will be a bit top. ওটাকে bail in connection with appeal এর hearing এ দিয়ে দিও। Yes, call the list. Item 1.
Yes, Lordship.
You don't want to proceed.
Yes, Lordship. And I made an affidavit, Lordship. Kindly, I submit this affidavit.
So going on,
Amicably settlement between the parties.
it has been settled.
Yes, Lordship.
Who is you are there? You are for the appellate. This is a Madness appeal.
He responded was L1 bidder. He after being selected, he filed an application for withdrawal from the tender process. So he was blacklisted and unexpectedly was forfeited. He filed a writ for return of the honest money and challenging that order. And
Then
challenging that order, we have filed this whenever the bill because.
they have, you have got back the earnest money?
No, it is with us, with the department. Respondent is seeking refund of the honest money.
Oh, I see.
That was settled, he is not claiming the honest money. We have also not giving.
Have you given notice?
Yes, they have filed. We have informed them, the respondent has executed that undertaking now.
The Mr. Bormon learned advocate appearing for the appellants submits that the appellants do not want to proceed with the present appeal any further. Press for do not proceed with the appeal any further. In view thereof, the appeal and the connected application are dismissed as not pressed. So let the affidavit, as filed, be kept on record.
Well, item number 2 and 3, my lord, this is related to the voted over case number 1063 of 2023, my lord. Is it same case, my lord? Item number 2 and 3, my lord. It's a case of my lord, suicidal death of a mother and the unnatural death of a daughter. And my lord, the investigation is right now, my lord, proceeded with the all the formalities, my lord. On last of it, my lord, on 29th, my lord, 29th January 2025, my lord, last order, my lord. My lord, kindly appreciate, my lord, para 14, 15 and 16, my lord. As per the direction of the previous bench, my lord, the report is right now.
Who is your other side?
My lord, the other side.
No, why it has come today? Why it has come?
Well, kindly page number point number 14, 15 and 16, my lord. The Commissioner of Police has directed to, after 15 days, my lord, there is the report before fortnightly basis. Produce the report before your lordship, my lord.
Then where is the petitioner? You must give a notice to him.
But the usual course matter will disposed of, my lord.
Matter disposed
Matter
of.
disposed of. In the bail application, my lord, matter has been
Yeah,
disposed
just
of.
let
Regarding
us-
only, my lord.
Only direction upon.
Only direction upon the investigation agency to produce the report of the investigation proceedings, progress of the investigation proceedings, once in a fortnight, my lord. Today is the first occasion after 29th, my lord. So we are producing the report.
Very good, but why we are doing it in the absence of the petitioner?
My
Who,
lord,
Sampad Das, who is the petitioner's advocate?
My lord, actually, may I, my lord? Actually, bail application and anticipatory bail application, both the petitions were already disposed of.
We understand that, but the matter has not been disposed of.
my lord, so
Matter disposed of, my lord. Matter disposed of.
bail application has been turned down, my lord.
Only direction upon the investigation agency to produce
Produce
the.
the progress of the report of the progress of the investigation.
Yes.
Where are 14, 15 and 16, my lord, direction. On previous occasion, my lord, bail drawer has been turned down. by the coordinate bench, my lord.
But this, none of the advocates are present out of the writ petition, the petitioner's advocates are not present. Somebody, the three persons appear. Are you there?
Item number 3, Mr. Jaydeep Kanto Bhomik is there, but he is on his way.
On his?
He is on his way.
Item number 3, Mr. Bhumik is
Item
there. my lord.
Yes, they are Mr. Bhomik.
Yes, yes.
Now, the
report
item
that-
number 3. Now, who is in item number 2?
On both of our bail prayer was rejected.
Yes, but it was kept under court monitoring investigation.
Yes.
So, can we record your name in item number 2 also?
I have no instruction.
Mr. Bhattacharya appeared,
Hmm.
Arun Bhattacharya, on behalf of my
But
lord.
he has no notice na that you will be
My-
mentioning for filing
My,
that report.
the order also not reflected, my lord, that's why. There's a only upon the,
Mr. Chakraborty learned APP appearing for the state respondents. No, এরম লেখো, pursuant to the order dated 29 January 2025, Mr. Chakraborty learned APP appearing for the state respondents files the report of the commissioner, as called for by the said order. Let the same be kept on record. List the matter for further consideration. Next circuit is from
next circuit is for my lord, first, third March. Third March. Third March. Third to 13. 14. 13. 13.
fortnight বলেছিল ওঠেনি তো।
Once in a fortnight, my lord.
Then when you will file a further report, because you shall
My
some
lord, my lord,
on
kindly
fortnightly.
mention the date, my lord. I'll produce the report, my lord. Copy হতে পারে।
এটা বলেছেন আমরা একটু progress on the fortnightly basis এ করবো।
Then after fortnight.
Fortnight বলে কি next fortnight এ তো
বলে দাও।
হ্যাঁ?
বলে দাও।
কিন্তু circuit
না,
থাকবে না।
পদস্থ ওঠানো হয়।
Fortnight হলে
Immediate circuit তাহলে করবে fortnight পর।
সরকারি কোর্ট আছে তো? 6 March.
Investigation complete or going on?
Going on. 6 months, my lord, maybe that date can be.
let the same be kept on record. List the matter for further hearing. List the matter. We are saying it will appear fortnight after hence, then fortnight, if there is no bench, it will go to the next bench.
My lord, bench will available on after 15 days, my lord.
আচ্ছা তাহলে লিখে দাও, let the matter and
6th of March, my lord.
list the matter, list the matter on 3rd March. List the matter
On 3rd
on 3rd March.
Great.
পরেরটাতেও same order করে দেব।
Grateful, your lord.
Great.
I'm just with your lordship.
Clear? She is for the petitioner
Lordship, I am for the de facto complainant, lordship.
in both the matters.
No, lordship, in item number 2.
ওনার নাম দিয়ে দিও de facto complainant. Yes.
Great.
Great.
One line, report kept with the record, my lord.
We have said.
But I am for the petition.
Yes.
Kindly see page 9 of my application. Interim bail was granted on 31st of
January 2025. As because my brother had expired,
Yeah, just. It was due to appear, it is due to appear on 17th
yes,
February.
ma'am. Till 15th bail was, my lord, interim bail was granted, and 16th, my lord, petitioner was directed to surrender before the correctional home, and 17th, the report, my lord.
Now, what is the problem?
My lord, after my mother is aged about 63 years. After the death of my elder brother, my lord, my mother became ill and was admitted in the hospital. Kindly see page 15.
Have you filed any application?
Yes, but his application, my lord. CRAN application, my lord.
This one, this application?
Yes,
you have
CRAN
filed?
1, my lord.
Acha, acha, yes.
Kindly see page 15 of CRAN application, page 15.
She was admitted then?
Yes, but she was admitted on 8th of February 2024 with chest pain and breathing issue, my lord.
Page
But-
18.
Page 15, my lord. Page 15 of CRAN application.
On 8th February, yes.
But I am praying only, but kindly extend the, my lord, the modified the, my lord, interim order for, my lord, at least, my lord, 15 days, because there is no male member in my family to my lord, look after my mother, because my mother was admitted in, my lord, nursing home, my lord. I am not praying for, my lord, confirmation of bail, but kindly extend the time for a certain period, so I will look after my lord, mother, my lord. Because at present my mother was admitted in the hospital. She is aged about 63 years. My father had expired many years back.
You are the only son?
I am the only son.
Your daughter, your sister's son?
No, but I have a wife and minor child, my lord, and only male member is. Yes, that's 16 to 2025.
Oh, different. Modified.
The first of the different cause, extent code also.
এক্সটেন্ড করতে বলছে যেহেতু 16 কে সারেন্ডার করে কথা আছে আজকে তো 15
Standard code the also. But if I
করলে তো রাষ্ট্রের দিকে নিয়ে
I never worry about it. The interim. About press consideration.
Yes, what do you say?
Lordship, this is NDPS case, Lordship.
But I am not on merit.
Mr. Bhomik, if you should,
Oh, wow.
8th, it was 8th, your mother has been hospitalized. Today we are on 15th.
40.
You filed the application when?
12.
You filed the application on 11th February.
Yes, please.
Thou, if you repeatedly come with excuses,
No,
once
madam.
the court has.
For last time, but unfortunate incident was happened due to my death of my elder brother, my
So
lord.
you surrender and come, we will consider on 17th.
My lord,
Under interim bail.
but if I surrender, my lord, but I have no difficulty for surrendering, my lord. But I am praying for only extension of time, my lord. If you lordship had me pleased to extend after surrender, but kindly give it that order at present, my lord.
You surrender before the correction law, then come,
But
please surrender.
then, my lord, the matter, my lord, was placed on.
Order is there to be surrender. Comply করব order থাকছে।
surrender করলে তো আবার interim bail চলবে।
ওরা comply করা উচিত। Action তো comply করা উচিত।
You comply, Mr. Bhomik. Come back to us on 17th.
For 17.
And you also take instruction whether he has surrendered in compliance of the order or not.
That was reflected, my lord. That direction was given in the order.
We know that, that is why. Yes, next.
Item number 5.
In place of 50, it would be 60.
By reason of a typographical error in the penultimate paragraph of the order dated 12th February 2025, the number of the bail application has been incorporated as quote unquote a CRM bracketed DB 50 of 2024 unquote in place and instead of quote unquote a CRM DB 60 of 2024. Stop. Office is directed to effect necessary correction. Yes, next.
Item number 3.
Lordships, in this case, IO set is on the way along with the seating. Kindly make it
2
possible.
PM, 2 PM. Yes.
Obliged, your Lordship.
7.
Item number 7.
I for the statement.
Yes, contraband recovery.
Yes, my lord. And out of 14 witnesses, already 9 examined and this is the, my lord, last order sheet of the lower court.
Who is for the petitioner? Sayantani Das.
Lordship, in this matter, I'm praying for 1 day's accommodation, Lordship. Briefs changed and need to some document on record, Lordship. Need to file.
Yesterday also it was taken up.
Lordship, brief has been changed and we are going through on the record, Lordship, but need to file supplementary affidavit.
Then it
Lordship.
will go to the next circuit.
Lordship, kindly 1 day's accommodation, Monday we will move the matter, Lordship. 1 day's accommodation.
Last order sheet, my lord. It was fixed for evidence for CSW remaining witness.
12:30.
Yes.
Lordship,
9 already examined, my lord.
Lordship, we have to evidences on.
Total is
Total 14 witnesses. Out of 14, 9 examined already. And in the next month, it is fixed for.
1 day's accommodation, Lordship.
appeared on Wednesday.
Lordship, I'm grateful.
Yes, next.
Item number 8.
This matter was already on the last occasion, it was part of my lord. CDR, my lord, this is that matter regarding the WhatsApp calls, and my lord was pleased to call for the CDR. I was present with the CDR.
That WhatsApp encrypted calls.
Encrypted.
Just
One
remind
thing-
us, Mr. Poddar.
I am not prepared name accused person, madam. My name transferred on the basis of statement of co-accused. And there is no recovery. I am custody about my lord more 88 days. And during police custody,
Nothing was
nothing
recovered.
was recovered. Only they saying that I have talking with some of the person. Not with the accused person.
Charge sheet submitted.
Not charges submitted, 88 days, my lord. Charges not, I will cover with the investigating agency, my lord. And there is no intimating material against me. There is no previous antecedent also, my lord.
Yes, Mr.
My lord,
Chakraborty.
the co-accused statement, which is in page number 96. The phone number of this person is there, and we have taken the CDR. There are some conversations on the first page, another page, we have marked it.
Second page.
No, first, second page, yes.
Silent. 91233 belongs to the petitioner.
So that was his mobile, that 9189 is who?
Malad, I may be excused, Malad, I have written a small R, that means Ravinder's number. And
Ravinder's means Ravinder's number and
here is the email, you know,
the person who has been arrested.
My,
The
witness.
Witness.
Page number 96.
I have not called
301, page 301 and 302, the 164 statement, those witnesses.
Witness have call করে witness
Some other person, not the package person, who was apprehended contract.
Oh, আচ্ছা আচ্ছা। So they were the witnesses of witnesses.
Those are witnesses, 164 statement, my lord, is there.
No, witnesses in the sense that they were,
To confirm that this number belongs to.
they are the neighbors, something like that, neighbors. ওকে কি ওকে করছে
Only confirming the number.
ও করেছে ওকে ও করেছে ওই একই উইটনেস করেছে উইটনেস করেছে
witness আর করেনি, witness তো
উইটনেস তো আছে নেভার
They are not the neighbors.
নেভার কে করেছে নেভার whether the that
They
witness
were not the neighbors, but they were well acquainted with the other one.
No, Mr. Chakraborty, if he rings up his neighbor, the person Ravindra has rang up neighbors, what does it establish? Suppose I ring you up, so at best I must be knowing you, that can be there. But what is the culpability?
268 is the screenshot of phone of
Yes. 260, yes, you showed us that. yeah?
WhatsApp call. And there is the name of Salman,
Yes.
91233.
Huh.
But the
That
name,
phone number belongs to Ravindra.
and this is the
Now
screenshot
that
of the
phone number
driver.
belongs to Ravindra, who by this he called whom?
Yes, madam.
This chart which here calls from Ravindra's mobile,
Yes, the
to
driver.
whom? To whom?
The driver, Abu Tahir.
So where will you find it? That he rang up Abu Tahir?
Because this is the encrypted one, the WhatsApp call. You can only
We cannot get the details, only we can get a screenshot.
Conscious behavior.
investigation going on or something like that.
Yes, yes.
Traffic or something.
Chachi, not
Universal report not collected.
What are the contraband articles? Cup syrup.
Contraband articles huge.
54,000.
Back it up. Well, the thing is that if my lord goes to
50,000, more than 50,000.
54,000.
well, if my lord goes to the seizure list, my lord will find that the way the person was carrying it was within his knowledge, the driver, because the bottles were down and above that some bags were there of marble dust. That means that was they know that they are carrying some contraband articles, so they have hidden that meter because nobody will keep marble dust box on the top of the glass box bottles, my lord. So now regarding the connection with this.
Who was the driver?
Abu Tahir.
And what is ER? ER you have marked?
Here is what?
Here,
The name is there, my lord. Iramul on the left, on the right side. my lord.
বুঝতে পারছি না। লেবাররা এসে 164 স্টেটমেন্ট করে কি বলবে? যে আমরা ফোন করেছি।
ফোন নম্বরটা অ্যাসাইন করেছে যে ওটাই এই ফোন নম্বর ফোন করেছে ওই উইটনেসকে নেবার ফোন করতে নাকি ওদের সাথে কথা নাকি প্রিন্সিপাল অ্যাকিউজড ডাইরেক্ট ফোন দেয়ার ইজ নো ডাইরেক্ট ফোন কল he used to call the that
He has called twice.
নাকি ডিরেক্ট ফোন
না এটা হচ্ছে বোধ হয় এরকম ওই ইয়ে
এইটা করেছে কাকে করেছে তো বুঝতে পারছি না। From this page 268, whom he has called is not evident, na?
It's the screenshot of the phone of the co-accused, but that's.
Co-accused means we,
Right.
oh, that this call came from that phone number.
Yes,
and he's in custody.
All of this.
Investigation not completed.
no, traffic not submitted. Save the report not submitted.
No point, Maintainability material came up. Only.
I was supposed to see the answer.
Screenshot, my lord.
88 হয়েছে
Investigation চলছে।
প্রফেসর রিপোর্টটা পাশে হবে
54,000
ভর্তি করতে হবে লরি একেবারে সম্ভব না করা।
Sorry, Mr.
After before passing order, I rely two judgments. If your lordship after thereafter your lordship pass order, I have no difficulty. Many
What is the,
if
This is-
substance of the judgment, if there is if any telephonic conversation, there is no power granting bail to the accused in individual's case. In circumstances, there is no recovery and there is no monetary transaction also, my lord. In this judgment, para 25, my lord, relevant point.
this is of Delhi High Court?
Yes, my lord. Delhi
Para?
High Court, para 25.
What was the quantum of, what was the amount seized?
মানে commercial quantity. All are commercial quantity. There is no direct.
Paragraph?
25, my lord, Yes, my lord. My lord, I have told three, my lord,
So,
kindly.
Mr. Poddar, learned advocate appearing for the petitioner submits Thursday, next. No one appears, order legal, no one appears on behalf of the petitioner. Though Mr. Luxam, learned advocate appearing for the state respondents is present. So in view thereof, list the matter for, as a last chance, comma, the matter stands adjourned, list the matter for further consideration on next Thursday করে দিও, ডেটটা বসিয়ে দিও। Yes.
My lord, item 10 and 12, my lord. His diary is not available with us, my lord. Kindly fix it on Monday. 10 and 12.
10 and 12 Monday করে দাও। 11,
Here, my lord, I beg to appear on behalf of the petitioner, my lord. My lord, this case pertains to an allegation where in the month of January 2024, contrabands were recovered from one person, namely Shantanu Mojumdar. Subsequently, my lord, that person has died during custody. My lord, from his confessional statement before police authorities. My lord, from his confessional statement before the police authorities, my lord, my name turned up. Now, my lord, I surrendered. Your lordship will find that, my lord, I pleaded in this in my petition, but I crave leave to place before your lordship the certified copy. My lord, one copy for my lord justice.
no, you surrendered when?
My lord, I surrendered on 24th of October 2024. My lord, I appeared before the police authorities after obtaining instruction that such an incident has occurred. My lord, I could not move my anticipatory bail application. Since then, my lord, I am in custody. My lord, no criminal antecedent of any kind has ever been placed against me. My lord, the persons from whose confessional statement I have been implicated, my lord, he has been died, my lord.
Yes, Mr. Chakraborty.
My lord, 161 statement is there, my lord, and the name of the person and as the associate is there, my lord.
My lord, he is the last.
He has already expired.
Expired in in jail custody, my lord.
Only one arrestee, only one person
arrest.
arrested.
But there are circumstantial evidences, my lord, from where it can come to a conclusion, my lord.
That is just 161, my lord, does not have any corroborative value. And my lord, another thing that has been stated in the charge sheet, my lord, that is, I have confessed my guilt. My lord, that is against Article 20, Clause 3, my lord, in my humble submission, my lord, that cannot also be proved against me.
Yes, charge sheet submit.
Yes, my lord, charge sheet.
Charge sheet submitted in 28th of December. Shantanu Mojumdar.
Who was the person expired, arrested person expired?
Shantanu, only one person was there, Shantanu Mojumdar.
Oh.
My lord, I surrendered on 24th of October 2024, my lord.
When was
Lord,
this?
quantity is huge
Yes,
quantity.
yes, 12 January 2024.
Man.
ওই যে মারা গেছে, যে অ্যারেস্ট হয়েছিল, You are a resident of Bihar?
My lord, I am a resident of Bihar, my lord.
The court is which police station is this?
My lord,
Bhaktinagar
Bhaktinagar police station, my lord.
And the court is at
The
outside
Jalpaiguri.
Bhaktinagar.
Jalpaiguri.
Outside Bhaktinagar.
Yes, yes.
My lord, in
Within
the district of Jalpaiguri, but
so
Bhaktinagar police station comes under the Siliguri police commissionerate, my lord.
45 kilometers.
Mr. Learned advocate appearing for the সুদীপ গুহ রায়। You are Sandip.
My lord, Sandip Guha.
And you are Mr.
He is Sudip Guha.
Oh,
May I, my lord? My lord, this is a case under section 21C and 29 of the NDPS Act, my lord. The allegation is that on 1st of January 2024, petitioner was apprehended and from him commercial quantity of tablets have been recovered, my lord. My lord, he is in custody about 410 days, my lord. Charge sheet is submitted on 24th of May 2024. My lord, till date, no charge have been framed. So in the meantime, my lord, the petitioner have been filed a bail application before this honorable court. Is at page, my lord, 10 and 11. My lord, kindly come to the page 11 once, my lord.
You are Raju Shah.
I am Raju Shah, my lord.
Yes.
In the
Para
page
6.
para 6, my lord.
You are the recovered from you.
Recovered from me.
Use quantity.
In
3,500 tablets.
my lord, in para 6, there is a direction upon the learned trial court to frame the charge, my lord. But my lord, after 3 months till date, no charge have been framed. And my lord, another co-accused have been granted bail. My lord, he is on different footing. That is the admitted fact. Recovery has been made from me.
Any person arrested apart from him?
One person have been arrested and he have been subsequently granted bail, my lord, from him.
Where is the seizure list?
My lord, page 46. Page 46.
Page 12 is a bail order of another person. Page 12.
Another accused person
Yes.
granted bail. My lord, page 46.
12.
My lord, is a seizure list.
12 is another person who was granted bail.
Yes.
He was in different footing, my lord.
He was not, that is co-accused.
He is a co-accused.
And lordship, it's kindly page number 40, 41 and 42. Why the charge are not there after passing of this order?
40.
40, 41 and 42. Last 3 dates after passing of this honorable order. The co-accused absent, not present. For that reason, trial court directed the surety to produce the accused from the trial.
That is, my lord, that is beyond my control, my lord. If he is not appearing, my lord.
Who is this person who is not appearing?
My lord, Afzal Ali.
Afzal Ali, co-accused.
He is, from him recovery was made.
Co-accused.
Co-accused. He is not appearing. That is why considered.
My lord, 410 days in custody.
Surety already directed to produce.
When is the next date fixed for charge framing?
My lord, 42nd of February.
Today. Today is 14.
For framing of charges?
Yes, sir.
Next Thursday.
Good.
Yes.
So, Shyam for the petitioner. Lordship, before I start my argument, I fairly submit that the petitioner at the first instance did not
Number 16, the Pathopathy for the petition.
16?
The Pathopathy for the appearing for the petition.
Not today, next 17?
Not in 17, I appeared for the petition. But the charges are under 14A and 14C of the Foreigners Act. The petitioner, not the accusation against the petitioner is that he has.
কনসুলেট কে পার্টি করেছিল
Lord, I'll straight away take your lordships to the.
এই কার্তিক এই পিএটাকে লিখে দাও কিছু কেউ নেই লিখে হ্যাঁ একে বলো না এটা পিএটাকে সোমবার 14 Mr. Sarkar, come on Monday. Because there had been a Supreme Court judgment circulated. I'm just forgetting in my memory. Let us see that, then we will.
Yes. Monday.
Oh, sorry, Ghosh. There is a recent judgment on Foreigners Act.
Yes.
14A. Hey, শোনো এই আমার ইয়েতে একটা এদিকটা দেখো এটা হাইকোর্ট থেকে সার্কুলেশন এসেছে একটা জাজমেন্ট ওইটা কালকেই বোধহয় দিয়েছে একটু বের করে রেখে ইয়েস নেক্সট
In item number 18, I'm on behalf of the petitioner, my lord. The service on the victim is not complete, my lord. May a direction may be given to the police to serve on the victim. Inform the victim, my lord.
Also,
No, my lord. 376D, my lord, Immoral Trafficking Act.
learned advocate appeared. You have served.
My lord, I have served, but it has not reached, my. Then, so I'm asking for seeking for my lord, a direction on the police to serve.
Any direction is required or you will?
What happens, my lord, actually, this service is done on the address in the complaint, my lord. Sometimes there will be, it may not match with the FIR, whatever address is given in the FIR. So the direction is required, my lord.
That means,
My lord, not required.
eh?
You direct the right.
Then when will you keep it?
On Monday, madam.
Monday হয়ে যাবে চলো Monday. Not today. 19.
Same foreigner statement. Monday.
আচ্ছা Monday.
Item number 20.
For the yeah, right.
Item number 20. Yesterday, an anti-50 bill was taken out, and the lordship had directed to translate that 164. So I'm giving that translation on Monday.
Same case, different accused. There was anticipatory bill that is 439, my lord.
All
I have
right,
got-
Monday. Yes, next.
Item number 21.
My lord, item number 21, already FIR name 2 of the co-accused has been enlarged on bail by the coordinate bench. My lord, page number 26 and 28. My lord, coordinate bench granted when FIR name co-accused, my lord, and this name has been transferred from the charge sheet, my lord. No antecedent, nothing, my lord. He was not present in the spot. Name taken by the co-accused, my lord. My lord, page number 26 and 28, my lord, kindly see.
আচ্ছা, have you have not been able to go through the file?
Yes.
আচ্ছা ঠিক আছে, we are keeping it at 2 PM.
My
If
lord.
you cannot go through, you tell us, we will keep it on Monday. All right? If you have time, please go through it. Otherwise, we'll give you. Yes, next 2 PM.
Lordship, I'm praying for 1-day accommodation.
Why, sir? Why
Lordship, learned advocate on record is ill, so he's unable to appear before Lordship. Jasmine, learned advocate Jasmine.
Husband is here.
Husband is the principal accused and he is the petitioner.
How long in custody?
Only, my lord, Arrested on.
You are not ready.
4th of December 2020.
I'm not aware of the fact of the case, your lordship.
Not today.
Recorded.
Not today, yes. He's for the state.
Lordship, page 8 is the written complaint.
Page
8. I'm claiming bail on the ground of parity, Lordship. Page 8. May I read, Lordship?
Page
8.
Huh.
The written complaint.
Huh. Read.
Lordship, I am informing you that my brother Lakshmi Gurung, 43 years age, son of Amit Bahadur Gurung, was kidnapped by Pawan Rai. I am not Pawan Rai, Lordship. And others, his friends, on 8/8/2024. Now I pause here, Lordship. On 8/8/2024, around 3 p.m., if his brother was kidnapped, no complaint whatsoever has been lodged before the police. Prior to 11/8/2024, that is the present complaint I am reading. Then Pawan Rai called me from his mobile phone having number such and such and asked me to pay rupees 8 lakhs as ransom, which to be paid at Pradeep Dhaba near Fulbari at 9:30 p.m. on 11/8/2024, that is today. Basing upon the said complaint, the police goes to the said place and apprehends his brother Lakshmi along with other accused persons, 6 accused persons. Now, before I proceed further, I like to place the fact of the case. Lordship knows this is a civil dispute which has given a criminal jacket.
No. 8th he was kidnapped allegedly. Complaint was lodged on
11th.
Then this is the complaint.
This is the
which has
complaint.
been lodged.
Against
Pawan Rai and others did it. Then they called.
No. Pawan Rai called me from his mobile number such and such. Pawan called and asked me to pay rupees 8 lakhs as ransom, which is to be paid at Pradeep Dhaba near Fulbari at 9:30 p.m. on 11/8/2024. That is today.
Right.
So this is the information. The police and the de facto complaint goes to Pradeep Dhaba. Pradeep Dhaba.
And it goes to the place. And finds Pawan Rai.
Finds the brother as well as 6 accused person.
Brother is named?
Lakshmi Gurung, 43 years old.
Lakshmi Gurung, the petitioner.
No. His brother is the victim.
So police went on 11th August and found whom?
Found his brother who was allegedly kidnapped along with 6 persons.
Achha.
Including this petitioner.
Achha.
And Pawan also. Now, Lordship, can you see para 4 of my petition where I have stated.
You were arrested on that day?
Yes, Lordship.
So from 11th August you are in custody.
In custody.
Charge sheet submitted.
Charge sheet submitted.
Then para 4.
Para 4. That the actual fact is that the petitioner has been falsely implicated in the instant case. A civil transaction has been given a criminal jacket by the complainant Sri Devman Gurung, son of such and such of Nepal. Now, Lordship can take a judicial notice of the fact, and my Lord Justice Bishas being posted here knows the bit better than me even, that Nepal is one of the largest supplier of betel nut. And what happened? This Lakshmi, the victim person, he and this kidnapper, allegedly kidnappers, are friends. They had business transaction. The Pawan Rai paid rupees 8 lakh to Lakshmi for supplying betel nut, which he failed. Then they came to India. He went to Assam and told that either you pay me the betel nut or pay me the money. Then he called his brother that if you have to pay rupees 8 lakh or else they will not let me go. The brother cunningly gives a criminal twist that is a ransom money.
We are granted bail earlier till We are granted
Parity,
bail.
parity.
Lordship, parity ground. Kindly seize lordship, out of 6 charge sheet per person, page 9, bail of Riwaj Pradhan, page 11, bail was of Suraj Seva, and page 13, bail of Dinesh Seva.
Whether this accused person stands on the
Same footing,
Tell us.
They were amongst those 6.
those 6 persons. Same footing. By 2 coordinated bench.
Yes, yes, sir.
Lordship, while granting bail, this 164 was considered by 2 coordinated benches. By 2 coordinated benches. Page 9, page 11, page 13.
Ashwin, Mr. Ganguly learned advocate appearing for the petitioner submits that the petitioner is languishing in custody since
187 days.
Since 11th.
Since 11 August.
2024. 24. Stop. He has been falsely implicated. He has been falsely implicated. In a dispute which has a civil, which has civil traits. Stop. Co-accused persons similarly situated with the petitioner. 3 co-accused persons have already been granted bail. And in view thereof, further detention of the petitioner may not be necessary as upon completion of investigation charge sheet submitted.
Submitted.
Mr. No. You're Mr. No. Friday না ছুটির দিন এসে ছুটির দিন এসে তাই সব খুলে গেছে। Mr. Nargan, the advocate appearing for the state, opposes the petitioner's prayer and submits that there are strong implementing materials on record. Strong and as such. And that court cannot proceed on the basis of parity on a simplistic assessment. We have perused the materials on record, including the statement of the witnesses, and assessed the role of the petitioner. Stop. Upon such cumulative assessment, it appears that the petitioner is similarly situated with the 3 co-accused persons who have already been granted bail by coordinate benches of this court. Stopping view thereof, further detention of the petitioner is not necessary. Allow 10,000 2 suretities 1 local with a further condition that the
same condition of a belt out.
which is
Same condition.
There are 9, 11 and 13.
Same condition with the belt out.
কোনটা সবথেকে বেশি সেটা দিন। Paragraph 10 is the condition.
Okay.
Petition leave the territorial jurisdiction of the trial. In page 10 টা দিয়ে দেবে। ERAITS.
Same condition that's there.
That
The petitioner shall not leave the territorial jurisdiction or transport.
কি লিখেছে? In a dispute pertaining to civil transaction করে নাও। Civil trades নামে pertaining to civil transaction হয় না, এটা trade 3 হবে। Civil trades characteristics. Yes. Monday.
Item number 25. I'm from the state.
On the last occasion, we also directly to file some documents.
Yes, my lord, that is my lord, the calculation of Raja. My lord wanted to see if they have a deed. They wanted
Lordship,
to
that
file
documents are not collected yet. I'm praying for not today.
Next Thursday, yes.
Great.
Item number 26.
In item 26, it is allegation is under section 64 B.
What is that 64 corresponding to? 370.
Lord,
You are the principal accused.
Lord, I sent the notice to the victim lady via speed post instructing the address from the FIR. But that report is showing that on 12 February 2025, it has been returned at address not found. So our humble submission that each state can make the required.
So we have to pass any formal order.
And one submission that the matter can be listed subject to satisfaction of lordship on Monday.
By Monday, will you be able to intimate?
Yes, ma'am.
Mr. What's your name?
Mr. Kidnapping.
Learned advocate appearing for the petitioner submits that the service upon the victim has returned, what it was not received.
The date is 12 February 2025. Item return address cannot be located.
12th February. Returned with a postal remark that quote unquote a item returned address cannot be located. In view thereof, state is directed to intimate the victim that the matter will be taken up for further consideration on Monday on 17th. Please the matter accordingly on 17th. Yes, next.
Item number 27.
Why?
Not
Then why you are filing? Why did you file? No, it cannot be your sweet will. We also do have a will to finish off matters. Repeated adjournments why you're taking, then you ought not to have filed.
Not place. Not prescription.
তো বললো না শুধু you have the learned advocate appearing for the petitioner submits upon instruction that the petitioner or petitioners does not want to proceed with the present application. In view thereof, the application being approved is dismissed and not pressed. Yes, next.
Item number 28. For the petition, for the state, your lordship.
Sections
For the state code 424, 60.
424.
68, 470. 470. Now, one of the cases very surprising.
68 copy. দেখতে হবে। এই আইপিসি টা দাও না একটু।
Both documents. Both documents.
এই একটু আইপিসি টা দাও। আমাদের এখানটা রাখো না। এই যে আইপিসি এখানে রেখেছো। এইখানটা সামনে এনে রাখো তো ওই তিনটি ওই দুটো এখানে রাখো।
But before paying for
এখানে
bail,
দেখাও।
Joyous person.
Yes, forgery or engineering. Yes.
Before paying for bail, Joyous person attention about the place of 15 and 16. Particularly the last portion of the place of
15.
15. One fact. Particularly the 16 is very well. Last portion of the 16.
What is it you are reading?
Actual fact is that the de facto complaint is my uncle. He was with me. And I purchased some plots from him by way of gifting. But subsequently,
Purchased, it cannot be purchased. Gift.
gift, obtained, maybe. But subsequently, my uncle went to my cousin brother's house and stayed there. And
At the time of gift, there was a consideration money was paid, that is 15 lakhs. Out of 15 lakhs, we have spent 1 lakh for his treatment. That is 14 lakhs lying due. Now, my lord, page number 15, now the initiation of this case,
Now, the gift was executed in whose favor, Animesh or Santosh?
on petitioner.
Santosh was also.
This is also a brother of.
Acha, very good. Gift was given to Santosh. Acha, তারপর?
Now, my lord, can you see the page number 6? When he left my abode, and the money lying.
Which portion?
Bottom line,
Therefore, I will be kindly furnish the details of your bank account to mine.
14 lakhs lying with me, it is admitted position. I am ready to pay. After receiving that notice, he lost a complaint at PS, but as the matter relates with civil favor, it was not accepted by PS. Then he lost a complaint by the 156 clause 3. And on the basis of that complaint, this case was initiated. Now, my lord, I am ready to
No,
pay.
why ingenuine deeds allegation is there?
I thought he went with me to the register, office of the register. He executed gift deed.
He executed how many gift deeds did he execute?
My lord,
Page 16 bottom schedule relates to the land.
now 7.
There were paragraph 24, it refers to sale deeds. You are saying gift in favor of minor Nishan Roy. Santosher minor ছিলেন না।
By his father, Santosh Roy. My client and another. My lord, so far as consideration money is concerned, I am ready to pay.
Complaint আছে complaint. Where is the complaint?
He has a
156(3) complaint. Where is the complaint? What complaint is there?
Complaint is, my lord, page number 11, page number 12.
First part and last part.
My lord, your clarification can be the
Complaint.
complaint,
Part-
my lord, that will be misplaced from by my clerk.
Page 12.
I think CD will be listed. My lord, I may be excused for shunning this and mistake. My lord, can you get the idea of the complaint? Complaint is the case.
Not last part. The last. ভিতরে আছে।
164 is done by the already transferred to the grandfather who mistreated by the grandson.
How can I mislead it?
We have heard you, sir.
Actually, kindly see 164.
No, these two persons are the grandsons
Grandson,
of the
and-
complainant.
Yes, yes.
Then what did you,
They told that.
grandfather executed deeds in favor of them?
Yes, but they said in the 164,
Huh.
he has no knowledge regarding the gift deed. They had been to the for doctor's chambers and subsequently they obtained the signature. Kindly see
My lord,
164.
tenable story.
Mr. Bob, what is written in the
Page,
lordship, I have already.
162.
Yes, 160.
of the complainant.
It may be commission, it may be held on commission.
আমাকে ডাক্তার দেওয়া নাম করে আমাকে সাব রেজিস্ট্রি অফিসে নিয়ে গিয়ে আমাকে ছবি করে আমার জায়গা জমি সব লিখিয়ে নিয়েছে।
And lordship's 160 of the.
Charge sheet submitted?
No.
So you call the grandfather, he will go, whether he will accept the money or not?
Actually, so far the I was concerned, I had been to along with the CD. Yesterday I prayed for time accommodation and Mr. My colleague brother said I am ready to pay the amount regarding. But as per the instruction of the IO that the victim don't want any money and he don't want to give the portion of the land to the petitioner, your lordship. That is
How many deeds were there?
There is a 2 deeds here, lorships.
Where do we find that?
Lordship, they have sent a notice.
Yes.
And the notice itself clear. Lordship, that is pertinent to mention that one same dated 29/24, 2 other sale deeds. Here is they have mentioned sale. although it's a gift. Also executed in favor of your two grandson, one being cell deed number 6441 in favor of the minor Nishan Roy, being represented by his father Santosh Roy. Santosh Roy written the name of his minor sons, lordship. So here,
So two cell deeds.
yes, lordship, according to their, and they want to return back. So it is clear, if give deed knows better than me, your lordship, due to love and affections. But here is 164 and 160 are totally different.
But where is the fraudulent document?
No
Was signed.
Yes, it is obtained by fraudulent. Signature obtained by fraudulent, but as per his statement that he.
My grandfather is an illiterate person.
According to.
No, you are applying 471. And you are also applying forgery. Forgery means forgery, how it will stand does we do not know, because grandfather says that I signed, but I was misled to put my signature. This was the only.
And there is another provision.
But he must have gone to the register to have the deeds registered. The civil angle, can you oust from it? Then the cancellation of deed has to
As
be.
because there is a provision for cancellation of deed if someone fraudulently obtained, lordships. I know that aspect, your lordships, but the case has been started and they have stated in the 164 statement. The victim can also file for cancellation of deed before the civil court.
Investigation rules.
And when the petitioner verbally intend to give some money, that means that they have obtained. It's true. That is not a case.
Deeds were executed. And it was registered before the registry office, but the only point is that.
That is Mr. Bhomik's advice.
Yes, lordships.
Mr. Bhumik, learned advocate appearing for the petitioners, submits that the de facto complainant is the grandfather of the petitioners. In view of the dispute relates to execution of two cell deeds. And to resolve such dispute, the petitioner through his learned advocate. This is after this the complaint was lodged.
I have wrote the letter earlier.
Where is that letter?
15 and 16, my lord.
Date of the letter?
Date of the letter is 30/24, your lordship.
30th July.
Yes, yes, lordship.
No, it is 30th December.
30th December.
And when was the complaint?
Complaint my lord. Lorships, I have already sent to 11th January.
11 January 22.
Fine.
But
from the CD, there is no reflection in the any sort of notice. The notice has been issued to the.
No, that is annexed here.
Yeah, they have annexed, your lordship, but the CD did that will reflect.
That is to resolve the execution of two services and to resolve such dispute that
Petitioner? Learned advocate issued a notice to the de facto complainant on 30th December 2024. Subsequent thereto, the complaint was lodged on 11 January 2025. The petitioners are ready and willing to
Pay the consideration money.
He further submits that part of the consideration money has already been paid to the grandfather, to the de facto complainant, and the petitioners are ready and willing to pay the remaining 16 lakhs. 14 lakhs. 14 lakhs to the de facto complainant in view thereof. And as the dispute is civil in nature, the custodial interrogation may not be necessary. Mr. Sarkar learned advocate appearing for the petitioner submits that investigation is still continuing and and there are strong incriminating materials on record against the petitioner. We have heard the learned advocates and considered the materials on record. Prima facie, it cannot be ruled out that the dispute prima facie, at this stage, it cannot be ruled out that the dispute happens to be civil in nature. Considering the nature of acquisitions and the extent of complicity of the petitioners in the alleged offense, we are of the opinion that their custodial interrogation may not be necessary. Allow 10,000
To meet the IO, so for the
may not be more so when prima facie it appears that the petitioners would delay the trial by abscondence. More so when prima facie it appears that the petitioners are permanent residents of the district Jalpaiguri, and there is no possibility that they would flee from justice. Allow 10,000 to sureties one local with a further condition that the petitioners shall meet with the investigating officer of the case once a week till investigation is complete. They shall not tamper or influence the witnesses in the event of failure to cancel. 438 2টা বসিয়ে দেবে। বাড়ির কথা তো এখানে আসে না, যেহেতু
বলা আছে কন্ডিশনে বলা আছে তো পরে
আমি বলছি অ্যান্টিসিপেটরি বেঞ্চ বলছে চার্জশিট ফাইল হয়ে নাগাজি যদি ফাইনাল রিপোর্ট হয়ে যায় তাহলে তো ট্রায়ালের প্রশ্ন হবে না।
তো শেষ হয়ে গেল, কোনো শেষ হয়ে গেল।
সেই জন্য এই কন্ডিশনটা কি দেওয়া যেতে পারে যে ডোন্ট ট্যাম্পার উইথ দি উইটনেসেস?
দেওয়া যেতে পারে, তো চার্জ কি হবে তো জানে না কে।
চলো নেক্সট ইয়ার
Item number 29.
29.
Yes. Saying for 1 day acquisition, just to receive the city, only 1 day acquisition. Fixed it on Monday.
What are the sections? 18 contraband?
Cultivation.
Oh, আচ্ছা মানডে একটু দেখে নিন তো 18 অর্ডার কন্ডিশনে দাও। আমার একটা কন্ডিশন ছিল যদি অ্যাসেসমেন্ট না হয় তাহলে প্রপার ডিমার্কেশন না হয় পারবে। দেখবেন দেখবো। Yes, 31. 30. Again anticipated.
No. This is something different. A allegation against this person is a particular. It is about 80 years. And this is the counter blast of our family.
Counter.
Lordship, I need 1 day's time as the injury report, Lordship, the IO will be collecting on Monday. So kindly fix it on Monday because the injury report is not there. The main Lordship.
No, complaint you have seen against him.
Yes.
So for the complaint is concerned, there is dispute between two groups of two family members of female person. Subsequently, I came there, some of the allegation is concerned, and assaulted them and tried to outrage their modesty and also tried to commit rape. This is the whole about the allegation. Now, my lord, if your lordship kindly.
Lordship, the victim was Lordship admitted to the hospital, so I need the injury report.
ঠিক আছে সোমবার Monday.
Monday, Lordship.
Item number 31.
Yes.
Allegation against one Jalpaiguri. Jalpaiguri state 276, 417 of the attempt to commit Proposal the 417 of the Indian Penal Code in the year 2023. And in this case,
No, no, we keep what you are saying?
like in the year 2007, 2023, one FIR has been lodged. There are the principal accused was charged to state and
Yes,
plus allegation of promise to marry and sexual.
Jasibul.
But principal accused was Jasibul Sheikh. And I am the relative of the Jasibul Sheikh in the year 2024, 25. They have come with the allegation under section 74 of the PNS. But kindly see the FIR.
What is 74?
আপত্তিজনক ভিডিও ও ছবি রাখার জন্য পরিবারকে হেনস্থা করে মামলার আমরা ষড়যন্ত্র করে সমাজ ও মানুষকে দেখিও
Now, who are these petitioners? What is your relation with Jasibul?
I am the Nadi Shekh's রাষ্ট্রীয় Nadi Shekh.
Aktio means what?
I told my brother-in-law and
He is still in custody. The Jasidul is in custody.
2023 madam. In the present case, I don't have.
Now, where is the complaint?
Page number 8.
Same complainant.
Complaint is same.
Consider 164 statement of the
अब मैंने केस किया वो जेल में 3-4 महीने था उसके बाद जेल से आने के बाद मैंने मेरा रेप का वीडियो
उसका सास ससुर दिया उसका सास ससुर सारा गांव
लोगों को दिखाया
गाँव में रहने देते हैं और
वीडियो मैंने
थपड़ी चला आपकी लाइन मानने को
सेम एलिगेशन पे बेल दिया ছিল 2023
এটা রেপ কেস ছিল রেপের কেস ছিল ফটোগ্রাফি গুলো না দেখছিল
ছিল ওটা কেস ছিল 376 and 470
sorry promise to marry for
yes you did ওখানে 160 should
ওই কেসটা বলছে রেপ কিয়া
और बाद मेरा रेप का वीडियो उसका सास ससुर को
এই তো যেগুলো আছে সরি
उसका सास ससुर सारा गांव अच्छा
who are the petitioners they are the who are the petitioners present relative to relative who's relative
Naju Sheikh मेरा father of the the principal accused Jasibul Sheikh in the year 2023 but in this case
আমি ওরা আমার শ্বশুরের নামটা কি বুঝতে পারছি না 164 is father-in-law, mother-in-law deferred. Whether they are the father and mother-in-law.
But in the comprehensive statement,
কিন্তু রিকভারি তো করতে পারি ভিডিও তো রিকভার করতে পারি
Investigation complete, charge sheet.
Investigation going on, pen drive seized, proceed.
Pen drive seized.
Yes, page 18.
What did you find? Obscene pictures were there. Your page 18.
Eight,
Page 18. That is.
In the pen drive. And the product containing the personal videos of the company. No, we want to know you, it has been referred as Sasasur.
And Fajima Bibi Miller.
Sasasur are?
Raju Tek and Fajima Bibi Miller. Page number 8 Miller.
Page number 8.
They have a complaint Miller. They have Miller. Jasidul Sekes Kotur. Fajima Bibi. Amin Raju Tek Miller.
Naju Sheikh and Shajima. These are the father and mother-in-law of.
Father and mother-in-law.
Oh, that's a.
Kotur and Kotur.
So your marriage with Jasidul is you did not marry Jasidul.
Babli and Miller, I am the 3 and 4 in that fire.
Amin Hussain, Babli Bibi. Who are they? Amin Hussain and Babli Bibi?
3 and 4 Miller.
শাশুড়ি নাজু আর শালিকা তাহলে ওরা দুজন তো নয় 160
শাশুড় সারা গাঁও
Page number 20.
দেখিয়েছে
Page number 20, Lordship, is the 161 statement of defective complaint. Page number 20.
শ্বশুর নাজু শেখকে মোবাইলে আমার স্ত্রী নিশ্চিত ভিডিও সরবে এতক্ষণ নির্দিষ্ট করে নাজু শেখ সাজিমা আমিন আমি নাজু শেখ
আমিন মানে রিলেটিভ নট নাজু পাবলিক
এই যে সেই নিশ্চিত সহযোগিতা
বক্সিং পিকচার আছে
having heard the learned advocates and considered the materials on record heard the learned advocates appearing for the respective parties, considering the nature of accusations, considering the gravity of the offense, its ramifications, the learned advocate appearing for the petitioner submits that the petitioners are the relatives of the principal accused. No specific overt act has been attributed to the petitioners and they have been falsely implicated. In view thereof, custodial interrogation may not be necessary. Mr. Royal Learned Advocate appearing for the state submits Yes.
My lord, this is a case under section 14A and 14C of the Foreigners Act, my lord.
Oh,
My lord,
that
acting-
Tuesday. ওটা রাখলাম না
Tuesday.
Tuesday we will.
Good.
Next.
But I am for the petitioner, but service is not complete, kindly fixed it or endless demo. Is this 376 case, madam? And kindly, but if your lordship desire, kindly notify the victim by the state council.
Also.
No, multiple 376 major lady, madam. Major. Why, madam?
37.
Madam, she is a madam. She is a married lady, madam.
Married lady.
Yes, madam. And if your lordship want to hear what I am.
Have you sent? Have you
Yes,
sent?
yes, it was bagged, madam.
Huh?
It was bagged, returned. I have sent, but it was
Mr.
bagged.
Guhol and an advocate appearing for the petitioner submits that service upon the victim guard, victim lady is
Yeah.
not yet complete.
Yes, ma'am.
In view thereof, Mr. Nag and advocate appearing কি লিখলেন? Service stop. Mr. Nag and advocate appearing for the state is directed to investigating চার্জশিট হয়ে গেছে you can communicate and come ও তাহলে
But how can I communicate?
Mr. Google and advocate appearing for the petitioner submits that the service upon the victim has not yet returned. In view thereof, however, not yet returned, and he prays for an adjournment. So Mr. Nag is also, Mr. Nag appearing for the state is also directed to effect service upon the victim lady. List the matter for further consideration on
Wednesday, ma'am.
Wednesday.
Item number 34.
But I am for the petition. But this is a case of 302 and my lord 120B of the Indian Penal Code.
CD not here.
But then fixed in my lord Tuesday, my lord, because Monday I will not have it.
Wednesday.
Wednesday.
কার্তিক কিন্তু শর্টলিস্ট গুলো লাস্টের দিকে না আর বেল রাখবে সব শেষ হয়ে যাবে ওরকম ভাবে তবে লিস্টটা ওরকম ভাবে করতে হবে যেগুলো একজন কোন দিলে বেশি আছে এই দিনকে একটু অ্যাড করলে এরকম ভাবে ইয়েস নেক্সট
But I am for the petition.
35
Yes, ma'am. But offense under section 341, 323, 325, 506, 34 of the Indian Penal Code, subsequently added section 326, 307. But informant and the accused person are the adjacent neighbor, but they have a agricultural land side by side. The informant was cultivating potato in their own agricultural land, and the accused person is alleged that accused persons, but they are unloading the soil in their agricultural land. Due to that reason, a dispute had been cropped up between the parties, my lord. And what as per the allegation, my lord, one Bablu and my lord, Bablu also assaulted the informant, and what he granted anticipatory bail by the learned session judge. Total, my lord, FIR named accused is 4 out of 4, my lord. 3 granted anticipatory bail by the learned session judge. I annex the order, my lord, page 10 of my application.
You are Jahidul.
Yes, I am Jahidul, and as per the FIR, my lord, Bablu and my lord, Babul and my lord, another person is my lord also. Or kindly see the FIR first, page 13. Kindly see the FIR first, page 13 of my application. But as per the FIR, the
Just injury.
Displaced here.
Displaced. End of heart. End of armor. Discharge করে দিয়েছে সেদিনই ঠিক করে।
তিনদিন ছিল আগে।
He was hospitalized. Mr. Sharkar?
31st December, he had been hospitalized and
Who is the complainant?
but one malad
নামটা
Afruja Khatun malad.
হ্যাঁ।
Afruja Khatun is the complainant and also the
Any injured statement?
injured 164 years lordship.
Yes. প্রশ্ন করে আছে ঠিক আছে। সময় আমি নিজেদের জন্য আগে চুজ করেছিলাম তখন
জাহিদুল্লাহ। তারপরে
24 page.
এই নাম আছে জাহিদুল।
অন্যদেরও নাম আছে তাদের ছেড়ে দিয়েছে মেয়েগুলোকে ছেড়েছে
যেখানে ওই চার্জলাম
চার্জশিট সাবমিটেড
No, my very recent case, your lordship.
হ্যাঁ
4 January incident.
It is said by the learned advocate on behalf of the petitioner that he
But I am for the petition. But this is the NDPS case, Malad 21C, Malad. One Majidul had been arrested, Malad, by the BSF, and from Majidul, Malad, 66 bottle of penicillin has been recovered. And from the statement of the Majidul, I was Malad implicated. I was neither present in the spot, but no connection. Malad, kindly see the allegation. Kindly see page 11 of my application. But this is the FIR, Malad. As per the statement of the accused, I am the Malad associate, and one Milon is the Malad supplier.
Yes, sir.
Charge sheet not filed, your lordship. Investigation still going on, and they are
In FIR, your name was there?
Yes, ma'am. But kindly
No.
see page 11, last two line. During preliminary questioning, the apprehended person, namely Majidul Mia, revealed that the The seized contraband was supplied by following India's smugglers. That was the second page, page 12. Milon, husband supplier of the contraband item, and Ibrahim associated with the apprehend person. But I am the Ibrahim. The only that is the allegation only. Except this, nothing is there. And I even that is not the prosecution story that I am absconding from the spot. Neither that is no whisper in the FIR. Only this person was apprehended by the BS, and from his statement I was implicated. Nothing more, nothing less.
That's continuing.
Bhagya.
In the FIR,
They are on the spot and subsequently they have fled away.
Where did you find it?
Lordship, our CD, Lordship, page number 20.
Now, kindly see the FIR. FIR has been show motor lodged by the BSF person. He is the eyewitness of the incident, Marat. In the FIR, there is no whisper in the regarding the plea arrangement.
Border BSF intercepted and they are the smuggler. They are crossing the Bangladesh border.
No, that is okay, but this person, Ibrahim, he has been stated to be an associate of the apprehended person.
Yes, and from the statement of the person as though are chased them, they have said that.
Nothing has been recovered. I will comply with the cooperate with the investigation at any condition. I will cooperate.
And everything is done according to.
Nothing has been recovered, man.
NDPS guideline, your lordships.
I will come.
19th November.
But I will cooperate with the investigation, man, at any condition.
Surrender and obtain regular bail.
Yes, sir.
But I kindly, but
You will get regular bail.
but today your lordship granted bail. Many of them are matter. No recovery, man. No recovery. No, man. I am on the standing on the spot. Those matters also are statement of the co-accused, man. I am. Except the statement of the co-accused, nothing is there. But I will cooperate with the investigation at any condition, man.
BSF.
We didn't give
Yes, man.
Anticipatory.
Yes, man. Anticipatory bail, yes, man.
Anyway, then it must be a very, very rare situation.
Every factor of cases, every.
But except
Conduct and they are on the spot and subsequently played away.
Supreme Court
Initial stage charge did not find.
But at any condition, any stringent condition, but I will not.
Part by the.
But I face the trial, but any stringent condition.
Quantity, your lordship. 66 more than.
Not concerned on being put and granted in justice government or anticipated in this matter, but other persons who have been anticipated. They can to some cases involving after is a very serious issue. We therefore direct the state to consider as to report the civil content. It is said
Item number 37.
I am for the state order.
Allegation under section 85 and 108 of the PNS. Is earlier 498, 306.
85 and
108 the PNS. Earlier 85 is 498, 108 equal to 306 of the IPC. Madam. Petitioner before your lordship, madam. Petitioner number 1 is the father-in-law. Petitioner number 2 is the mother-in-law. Madam. Husband arrested now in custody. Victim committed suicide by hanging. Madam. Charge sheet submitted.
yes.
Yes, my lord. Within 9 months of marriage, the incident took. Demanding more dowry. The deceased was tortured by physical and mentally, and finding no other alternative, she commits suicide.
Injury, where is the postmortem?
Postmortem report, my lord, at page 70. Unknown poisoning, antemortem in nature. 70.
Individual হয়েছে সুইসাইড হয়েছে পয়জনিং
Poisoning.
to a person presumed detected. Nature of
The nature of the poison.
Unknown poison.
Where is the complaint?
My lord, page 2, at page 2. On the CD, page there. Father of the deceased was the complaint. Bail of principal accused was rejected by the earlier bail.
I'm appealing for the state file.
Yes, what?
There are two things that because your lordship manner allegation under 118, 117, 118, 109. Basically, manner allegation of previous are and against matter in the allegation matter. And one of the principal items for landlord and bail by the Honorable High Court matter I annex the order. I am the son of the principal item and charge it submitted.
Son of the, who is the principal accused? He has been granted bail.
By the Honorable Court, case 12. From my objective. And paragraph 3,
Yes, Mr. Montu has been given. Investigation over.
Investigation completed. There are 3 victims are there, madam. 3 victims are there. Kindly see the 164 statement of the victims. And
kindly see the page 13, paragraph 3, injury described as simple. Coordinate based of that.
দানা লাঠি
আমার দিকে লাঠি দিয়ে মারলে হাতে কাছে লাগিয়ে মারার পরে আমার বোনকেও মারছিল, বোনকে আমি চিৎকার শুনে আমার মা আসলো, মাকে মারতে ছোট জায়গায় আমার জেঠু অনেক পেপারতে থাকে, আমার জেঠু আমার ছোট দাদা আমার
দীপক মারা
জেঠুটা কে? Who is the brother-in-law? You are the son of Montude. Montude was the principal accused. You are the sons of the principal accused. জেঠু হচ্ছে ওই যেটাকে ছেড়ে দিয়েছে। জেঠু is Montu. Injury, Mr.
Malad, injury, page 57, 58, 59. Before that, Malad, kindly see page 29 and 30. Page 29, 30. Before injury report, Malad, kindly.
Statement on 61 statement.
No, Malad, the photographs of the victims. How can it be, Malad, written as simple? I don't know, Malad. In the, all the injury reports are.
Where is the injury report? Where is the injury report?
Page 57, 58, 59. 3 injury reports are there, written as simple.
56.
That is why, my lord, I request your lordship to see the photographs.
Deep cutting. Simple, deep cutting, simple.
Tick mark is in the over the simple. Kindly see the photograph again. Several stitches are there, madam. Several stitches are there. But anticipatory bail, they are filing anticipatory bail.
Investigation over.
Investigation, although my lord, investigation is completed.
What purpose will be served?
That's true, but
Further interrogation is not required. It is said by the learned advocate on behalf.
ছেলে দুটোকে বাইরে দিতে কিছু মেসেজ চাই। Relaxation hospital. You know,
it is said by the learned advocate on behalf of the petitioner that these accused petition
Photographs are and things are out of focus. Photographs are medical people are not matching. What should I do?
In item number 39, Lordship, I beg to appear on behalf of the petitioner. Petition allegations are under section 85 and 109 of the BNS, that is 498 and 307, read with section 3 and 4 of the Dowry Prohibition Act. Petitioners before your Lordship is the husband, petitioner number 1, and 2 is the mother-in-law. Allegation is this: 12 years back marriage took place, and out of their wedlock 2 children are there. One is more than 10 years, another is about 5 years or more. And allegations of physical and mental torture, demanding dowry even after 12 years. Lordship, kindly sees whether statement of its children were recorded to that effect or not.
Children are residing with whom? Children are residing with whom?
Earlier they were residing with us, and now with the mother.
No, my lord. Children's statements are not recorded. Only the neighbors and the victim herself has recorded the statement. That sheet is pending, and it was last rejected.
Pending.
Statute pending, lordship. It was rejected on the ground of 161 statement of the victim, as well as the 26 and page 27 of the case diary, where medical documents are there.
164.
164 not recorded. That is 161 of the victim, where she has stated that she was physically and mentally tortured by the accused.
Who is Jarina Beva?
Mother-in-law, Lordship.
Mother-in-law.
Yes, mother-in-law.
Yes, Lordship.
Injury report?
Page 27 and page 26, 27, bail ticket, lordship, physical assault is there, lordship. It is not so clear, lordship. Not so clear, lordship. I think he has not prayed for any injury report as also.
It is not the injury report, it is the
It is a
treatment
bail
paper,
ticket, yes,
admission paper,
treatment
something
card.
like that.
Lordship, it is the cases are initiated on 26/11/24.
12 years back marriage took place, Lordship, and if that would have happened, then there would have been statements of the children also. One is the husband of the victim and the
Children's statement is not there.
No, that is why, Lordship, I am saying, because no such incident took place. Some matrimonial discord may be there. Otherwise, statement of the children would have been there. And the accused petitioner number 2 is the mother-in-law of the victim.
Charge is pending, my lord, maybe.
It is 3 months over. Case of November, and it is February. By that time, they would have must have recorded the statement of the children.
We have heard you.
Grateful, Lordship, grateful. It is submitted by the learned advocate on behalf of the petitioners that both these accused petitioners have been falsely entangled with the crime. So, the entire allegation as made out in the complaint is totally false and concocted one. So no purpose will be served by detaining, by throwing these accused petitioners behind the bar for the sake of custodial interrogation. Stop. Learned advocate for the state raises objection by submitting that there are sufficient incriminating materials in the case diary which reflects about the prima facie involvement of these accused petitioners with the alleged offense. Moreover, the investigation process is still going on. So at this stage, the petition praying for bail filed by this petition praying for anticipatory bail filed by the petitioner may not be considered. We have considered the materials placed before us, perused the medical document, as well as the statements of the witnesses recorded under section 106 statement of witnesses gathered in the case diary.
Recorded under section
161 of CRPC. Keeping in mind the extent of their complicity in the crime, we are inclined to enlarge the accused petitioner in or to the accused petition number 2, China Bear. But considering the involvement and their complicity with the alleged crime, we are not inclined to enlarge, we are not inclined to grant the anticipatory bail to the accused petition number 1, rejected. 2,
Partly allowed.
partly allowed.
Okay,
1 reject, 2 allowed.
in the event of arrest, 10, who is the judge? Satisfaction of?
Arresting officer.
Oh, arresting officer, right. Arresting officer, 10,438 counsel.
Grateful, Lordship.
কি ধরে ফেলেছিলাম স্যার শেষ
First one, item number 6.
yes
Short process. No, no, no.
or we will start আচ্ছা
I
ঠিক
don't
আছে
have the CD.
ঠিক আছে পাসওয়ার্ড প্রবলেম you can do it today.
My lord, I'm led by forward.
Oh, he's ready with this. আচ্ছা ঠিক আছে pass over you inquired. Yes, next.
First one, item number 21.
My lord. My lord, this is under section 3104, 3105, 121, subclause 1109 of Barclays and Certificate section 25(1)(a), 27(1), Arms Act. My lord, he was neither present in the spot, my lord, not his name was reflecting in the FIR, my lord, after inquiry, his name transferred in the charge sheet, and moreover, my lord, two of the co-accused standing on the same footing has been enlarged on bail, my lord.
You are coming for the seventh time. First application before this court. Who is Ashish Giri? Your client is knowing Nobiul.
My lord, Salim Khan and Ashif Kumar Yadav has been granted bail, 28 page and 26 page. Nothing has been written against him, my lord.
Paragraph 3. Yes, what do you say?
My lord, this petitioner used to visit principal accused in Shobita Lodge. Only this is the charge sheet, my lord. There are
This is corresponding to 310. Section 310 corresponds to IPC.
my lord.
Huh?
IPC.
Decoy. Yes, sir.
Yes, ma'am. Third, this is the certificate copy I have for you. That one, it is in bad condition. Third para, they used to meet. This petitioner used to meet robbery.
Did here.
Yes.
What is putting persons of several states. Before us, it is Kiran.
No, my lord.
Kiran is the constable.
Nobiul.
Last name.
Who was the principal?
Principal accused, my lord. Ashish Giri.
And Salim Khan.
Salim Khan and two another also.
So Salim and Ashish has been given bail. Salim Ashish has been.
Yes.
And anything recovered?
Nothing. only this is they said that this Nobiul Islam is used to meet with those 4 accused persons in a lodge.
It is said by the learned advocate on behalf of the petitioner.
Not today. Next, 41.
Item number 41.
Lordship, I am for the petition.
Yes, what is the matter?
I just heard that somebody from the bar, local bar, died on, so all of them went to that case watch. From Jalpaiguri bar, some advocate died. So they have gone to.
Advocate died.
Died.
Biswajit Basu.
Vishwajit.
Biswajit, what is? He used to practice civil law.
District court.
District court.
He used to come here also.
No, his daughter is to come.
Alright, not today. Any problem?
No, Lordship. Lord, I am for the petitioner. Lordship, this application of bail pertains to the FIR which has been registered under sections 64 of the BNS, my lord, corresponding to 376 of the IPC. Right, my lord? And 506 of the IPC corresponding to.
You have tagged the letter. The report is also tagged there. It is not being able to be. You have the case there, no? Yes, tell us what is your.
My lord, if your lordship may kindly consider first the written complaint, my lord, which is there in page number 10
No,
of my.
let it be with the Kartik, এটা খুলেই দাও। এই পান, এটা ধরো তো স্টেপল মারো, ওর স্টেপলার নাও। এটা ছিল তো, এটা ছিল। ছিল তো, ভিডিওটা।
তিন ঘন্টা কাছাকাছি লাগবে, প্রায় 3 ঘন্টা, বলে গেল 2 ঘন্টা 2 ঘন্টা।
কি বললেন না বলুন না। পারলে না কি আমি করে দেবো? পারলে না? কার্তিকে তো আগে বললেন।
My lord, if I read out, if I may read out the written
Yes, what you are showing? Yes, tell us.
My lord, here it is clearly written. First, the most important point is clearly written that the petitioner tries to rape the complainant here. Page number 10. my lord. My lord, it is written that the complainant, my lord, she was alone and not well at her place. And as such, she went to a neighboring aunt's house. And going there, she could find that the aunt's house is also, the auntie and uncle is not there on account of their professional commitment. Then, my lord, it is written that finding that opportunity, the petitioner enters and he bolts the door, my lord. Can that be a possibility? If I am going to somebody's house, either it is supposed to be locked, or if I go there when they are coming out, then I am supposed to lock it from inside. And how the petitioner is supposed to know that that house is empty and he needs to go there and meet, my lord?
জবরদস্তি করার চেষ্টা করলো।
Yes, any injury report or anything?
Medical. This attendance.
Intention, preparation, then as.
If your lordship
Fail to execute.
Lord, if your lordship may
How long
kindly
you are in custody?
Lordship is anticipated.
anticipatory.
Oh, anticipated.
Lord, if your lordship may kindly consider the paragraph number 7 of my petition, my lord.
It is said by the learned advocate on behalf of the petitioner that including the statement of the victim under section 164 CRPC এখন কত আর include and the medical report বলেছি বোধহয় দেখুন বলেছি
Considering the involvement of the accused,
No,
petitioner,
even
we find,
considering
including the statement of the victim.
The original documents, statement also.
Forty-five and 46, same identical matter version.
mute this
46, I am for the state.
45 my lord or 46 my lord, I am appearing before the petitioner, my lord, that matter my lord, the petitioner initially terminated, my lord, then my lord allow the join, my lord, your lordships.
You have got that evidence?
In 46, I am filing the affidavit lordship. In 45, I am not for the state.
Who is for
Miss,
the state?
Bedusruti Basu is for the state. She provided me with the affidavit of opposition, and she said that some pages required to be changed for that. It has to be reaffirmed. The 45.
Reaffirmed?
45. 46, the affidavit are also ready.
So it's the same thing, na?
Yes, my lord, same.
আচ্ছা 46 টা ডাকুন।
I don't know what is it.
ওই 46 এর ফাইলটা তো এটাও এখানে থাকে তো। Please give the affidavit.
I am handing over a copy.
Oh, just now. আচ্ছা, let us see what ground they have taken. এফিডেভিটটা দিয়েছে।
Amendment of suicide.
Paragraph 21.
এটাই তো ভুল লিখেছি। এটাই তো ভুল লিখেছি।
Paragraph 21.
Page 7.
So you were reinstated on the basis of an order of 6th April 2017. When did you join? Did you join?
Yes, my lord.
Yes. When did you join?
My lord, join, my lord, this.
You were reinstated by an order of 6th April 2017.
6 April 2017 joined, restated.
On that date itself, he joined. Now he retired when?
31st January 2023.
2023.
Retirement.
Retired.
Now 46 Mala retired on 31st January 2020. 23 Mala is a 45 matter.
Acha, 31st January 2020 retired.
Retired.
Now, thereafter what happened?
But they did not release any pension, gratuity, or other retirement benefit. They stated there is a break of service.
Now, where do we find that order?
Malad, find this order, Malad.
Which order did you challenge before the tribunal?
Malad, tribunal challenge, Malad, that this order, Malad.
Which order?
Malad,
So
page,
after reinstatement, he joined. Then what did you challenge before the tribunal?
page 71, Malad, in 45 matters, Malad, in respect of
45 now, we are seeing 46.
46.
46, Malad.
Can you take up the 46 matter?
Yes.
Your OA was
page 63. Page 63.
Page 63.
This is the order.
Yes.
Page 63 start, Malad. 66, Malad, is the operating portion, Malad.
Yes.
In compliance. In compliance of the above order passed by the Deputy Inspector General Police, such and such, Piyushkant Jalpaiguri, he is reinstated in service effect from 6th April 2017 AM. In the same rank and pay, he is allowed to draw his basic pay such and such. Other usual allowance as per provision of the rules and pay accordingly. R.O. Jalpaiguri is directed to equivalent pay as per ROPA. He was not entitled wages or consequential service pensionary benefit in between the period from dismissal and reinstatement, as the period is under suspension and dismissed from service. I challenge.
So period in between the dismissal and reinstatement. So when was the dismissal?
When was dismissal on 8th January 2008.
8th January 2008.
2008.
And reinstatement was 6th.
6/4/2017.
6/4/2017. So you have worked for the period from 2008 to 2017.
I'm a suspension 2004 to 2008.
Suspension, give us the date.
2000.
2004.
2004.
To 2008.
2008.
Now, what are the dates?
Well, dates are the 23rd September to 23rd July 2004.
To
23rd July 2004.
2004.
Suspended. And you were reinstated on 8th January. When was it revoked?
Revoked on 6th April 2017.
No, there is earlier revocation of suspension.
Revocation at the time of dismissal, but that's still suspension.
So from 23rd July to 6th April 2004, 2008.
2008 the dismissed from service.
Very good. So from 23rd July 2004 to 6th April 2008, you were under suspension.
Suspension.
Now thereafter you were, then what is 8th January 2008?
8th January, this is terminated my service. This is not a July. This is 8th January, dismissal order.
8th January 2008.
8.
Which is the page number? Your dismissal at 8 January 2008. Where is that order?
That order, page. 9. Page 21.
Then there was an order of revocation of suspension. You showed us on that date, na?
No, there is no revocation of suspension.
So you continued in suspension from 23rd July 2007, 2004. Till your
dismissal.
Till the rejection, till the dismissal on 8
Dismissal
January.
from service.
Till 8 January 2008. This is the period of your suspension.
Suspension.
So after being reinstated on 6th April 2017, you retired on 31st
January 2020.
31st January 2020. Yes, so why you are not giving him pension? Now, Mr. Mukherjee, you went to the tribunal. Tribunal has said that I will hear it when the another member joins. So at this stage, what do you want from us?
Promise kindly dispose the writ petition. This is a also I relying a judgment. Your lordships arguing a matter in Devasi Sutradhar. Kindly place the junior that judgment. Your lordships that matter 12 years is a unauthorized absent. 50% back wages given. Your lords kindly see this judgment, your lordships arguing a matter in a way. This is a constable matter.
That was regularization.
No, this is the departmental proceeding.
No, departmental proceeding today, back wages, whether you will be entitled or not, we cannot decide that. Back wages, whether you, question is whether your continuity of service has also been disturbed.
But this time only kindly see is a page 45. Only their contention is as per this is an allegation 306. Crime.
No, your where is your your affidavit? What is the incast in terms of accordingly applicant was suspended on, here you are saying 19th of what date you have given? You are suspended. Suspended 23rd July 2004. That is the suspension with effect from 23rd July 2004. What you are writing here? How can he be suspended after dismissal?
That is the typographical error.
And typographical error, both typographical error. We wanted to know why you are not. Suppose he was in suspension. Suspension does not mean dismissal. you have dismissed him. He was suspension from 2004 to 2008. That is the date of termination. So up to 2008, he entered into service on which date?
46 Malad, 79. 46 matter Malad, I am entered in 79.
Sir, date, give the date.
Date Malad, 2nd November 1979.
2nd November 1979. So from 79 to 2008, he has discharged service. He was dismissed on terminated on 2008. The termination was also recalled. Termination order was set aside. Termination order was set aside. Now after
Termination after the judgment of the
whatever it may be, he was termination was set aside. He was reinstated.
His conviction was set aside.
Kindly come to page 66. If his termination has not been set aside, how did you allow him to join?
Piece of the direction of the tribunal. There was another letter. Tribunal directed to reconsider on.
So very good. You reconsidered, allowed
He
him
was allowed
to.
to join in the same court.
Huh.
But he back wages.
We are not saying back wages.
And
We are saying
that portion they have filed this.
no, back wages we are not considering. Why he will not get pension?
That is separate.
What separate?
That issue is challenged before the tribunal.
Tribunal, he made a prayer for what? Back wages, continuity of service. This court asked you to file an affidavit stating that why he will not get pension. Who is the in writ matters? Who is your government pleader? আমি যদি সাসপেনশনে রাখি আমার পিরিয়ডটা তো ইভেপোরেট করে যাবে না, তাহলে আমি যদি 10 বছর কমপ্লিট করে থাকি তো why will you not get pension? I think we are not being. He was suspended on 23rd July 2004. He continued under suspension till the date of his termination of service. Termination of service was on 8th of January 2008. After 9 years thereafter, he was reinstated in service for whatever reason it may be. What was the order of reinstatement? That you will not be entitled to consequential benefits and back wages. So consequential benefits means what? Promotion, etc., and back wages. But how your pension payment will be dependent upon the service rendered by the person. So he was in service. Why you are not getting pension? Hey, Mr. Ghosh, you are there. You appear in state government matters. Boju.
Kindly keep it on Wednesday. I will.
Are sir, how many times we will keep?
48 is also there.
Okay.
45 and 48. There is also.
Mr. Mukherjee, they have given an opposition, they have handed over to you, give a reply. What more can you say?
Sir, I have received one of which.
On a provisional pension.
There is certain pages are not eligible getting.
So you serve it in course of this day.
Malad, provisional pension can be released. Malad, the provisional pension.
So you are in item number 45. You are Mr. What was justice in agency submission? This lady appeared, we told her.
She's always, she's not well.
Sir, we want to know from the government.
So for pension,
He is entitled to provisional pension, sir. We will not, you disburse the provisional pension, treating the period from his entry into service in 1979 till the date of his termination. That period you can count towards calculation of provisional pension. What is the difficulty in that? You have to take instruction, na?
Lordship. Lordship, in this matter, last occasion I appeared, but I seek the help from Mr. Hero.
What you are saying?
Lordship, I am seeking the help of Senior Advocate Mr. Hirong Bormon in this matter, Lordship, to guide me in this matter, Lordship. Lordship, actually, we spoke with the
Mr.
department
Who
regarding
is
your queries, Lordship.
This is a question to be dealt with by your senior counsel. Who appears for the government? Government leader? You have any government leader here? Who is the government?
Lordship, Mr. Bormon is the senior counsel in this NGP panel, Lordship.
So, Mr. Bormon, without prejudice to your rights and conditions in the before the tribunal, you give him the provisional pension, treating him to have served for 10 years as an interim measure. Let him survive. He has discharged service on 79 till the date of termination. So how many years?
28 years.
20, more than 20 years. 79 to 2008, more than 20 years. So you calculate that person and give the pension. No, আমরাই বলে দেবো। আমরাই বলে দিই এটা।
instruction দেবে
Instruction না, আমাকে তো petitionটা order দিয়েছে দিতে হবে। এটা কি difficulty আছে আমি বুঝছি। Who is your concerned officer? You call your SP? So you better take the instruction, otherwise we will personally call this SP.
We are finding our evidence today. I will take the instruction personally. Tomorrow I will take all the instructions.
Please take the instruction and say that why you are not paying provisional pension, what is the reason? And if he doesn't give you instruction, then we will ask him to be personally present. Let the affidavit, Mr. Bormon, learned advocate appearing for the state respondents, files the affidavit on behalf of the respondents as called for earlier by an order passed by an order dated at
46.
by an order dated 23rd September 2024, as called for by an earlier order dated 25th September 2024 by a coordinate bench of this court. Stop. Let the said affidavit as file be kept on record. Affidavit টা করেছে কিসে? Where is the affidavit?
This has been 46.
46. This is an affidavit in opposition to what? সেটাও লেখনি।
To the writ petition.
Not to the writ petition. Direction was upon let the said files an affidavit in opposition as called for earlier by an order dated such and such passed by a coordinate bench of this court on such and such. Let the same be kept on record. A copy of the same has Mr. Bormon is directed to. Oh, you are not filing. Today you will file. Okay. A copy of the same has been handed over to the learned advocate on record of the writ petitioner in court today. All right. You are correct. List the matter for further consideration আছে কি বার শুক্রবার বৃহস্পতিবার কি বার on 20th. Mr. Bormon, do you have your brief? What is the order of justice? The coordinate bench. Coordinate bench was wanting to know petitioner is entitled to retirement benefits and why he should not be given the ad hoc pension at least. In the meantime, the petitioner would be at liberty to file the affidavit in reply. আর পরেরটাতে ওই সেম করে দেবে ওই মিস্টার ব্যানার্জি করে।
I have already filed that.
45 এর opposition, if you don't file, we cannot sign the order. এটা 46 এ রেখে দাও, 47 এ দিয়ে দেবো। ওইটা এলে তারপর সইয়ের জন্য পাঠিয়ে।
Item number 48.
48, I am for the respondent.
Appearing for the petition. My lord, actually the petitioner was enlarged on bail on 4th December 2024 with a direction to furnish a bond of 25,000, my lord. Actually, he's daily wage labor, my lord, financial stringencies along with his family, my lord.
May I submit?
After he was enlarged on
This
bail, his
application about
modification, my lord.
Just said the half of. My lord, actually the amount is 25,000. Two sureties of like amount, one must be local. Local surety, it's very 50,000 surety for a daily laborer. It's true. My lord,
no 50,000 for
one 25,000,
Each.
two sureties each means 25,000 plus 25,000, total 50,000 is a daily laborer.
So he could not furnish the bail bond, my lord, and he is still in judicial custody.
And in a local surety, one has to pay the entire.
If the amount is modified, my lord.
What are the sections involved? 420,
Yes, my lord.
2468, 409.
Hmm?
You are the only accused.
Yes, my lord.
what was the charge against you?
420, 468, 469, 471, 472, 409, my lord. Of IBC.
Who is the petitioner is the daily laborer?
Daily
Yes,
laborer,
ma'am.
409 has been.
How do we come to know?
My lord, maybe said in my corrected, my lord. He is a home guard, my lord.
So then why did you say daily laborer?
My lord, subject to my lord.
What you are saying, sir?
490,
So he is a home guard, very good. Then what is the problem in paying the amount?
My lord, it is 25,000 each, my lord. It is not possible for him to pay, my lord.
On what ground we will reduce it? Where, which paragraph you have stated?
My lord, in my amendments, five, my lord.
How long you are in custody?
He is on bail, my lord. On 4th December 2024, he was enlarged on bail, but due to the
How
amount-
long you had suffered up to
Suffered,
4th
my lord.
December? What was your period of detention?
He was arrested on 21st October 2023, my lord.
21st October 2023.
Yes.
So what you have stated here? Where is your ground for modification? Financially weak.
Yes, my lord.
Why? What is your salary? How much do you get as a home guard?
7,000, my lord.
7,000.
7,000.
7,000, sure.
Show your salary slip.
I don't have.
Verify the information. Brother, don't make
7,000.
As per the instruction I have received,
17,000.
yeah, this is my
Don't
instruction.
make such submissions. You go, take time and cut
Produce
it.
your pay slip. Produce your pay slip, justify your salary. Justify your salary. At the time of taking money, you did not remember that. Huh? That give me money, I will give you employment. Huh? Now you have become a poor man. In course of hearing, the learned advocate appearing for the petitioner prays for an accommodation to avail further instruction. In view thereof, list the matter for further consideration on the বৃহস্পতিবার দিয়ে দাও আর ওনার নামটা দিয়ে দিও রেসপন্ডেন্টের ইয়েস নেক্সট হ্যাঁ তাই কি
He has to produce the salary slip. Salary slip has to be produced.
his choice we have told him we have not recorded in the order. Now if you want to place Ingot
খেলাই না তো কন্ট্রাকচুয়াল লামসাম পাই
কি করবো দিয়ে দেবো হ্যাঁ দিয়ে দেবো মনে করছিল
করে দেবো বৃহস্পতিবার আসবে তখন
আনেবল বেল যখন দিয়ে দিয়েছে এমন কি কন্ডিশন ইম্পোজ ইয়েস নেক্সট
Application for restoration.
49
এই সেকশন 5 টা হবে ওটা বলো তাই আছে না
what
49, madam. There are two applications. One is application for restoration, madam. Another is section 5. There is code. There is 5 days delay. Within 30 days, there is 5 days delay.
you did not appear
Madam, there is a
or when was it dismissed
madam, it was dismissed on 3rd of January 2025. Madam.
on what ground
Madam, one appear. Madam,
you did
there-
not appear
Yes, madam. On another court, madam, for this thing is and within 30 days, there is a 5 days delay for this reason.
What is the main matter about bail
it's a POXO case, my lord. It's a bail in connection with the POXO matter.
POXO with section
6, madam.
section 6 do you have the case diary
Oh my. Let the restoration, because they have filed an application.
adjourn
Section 5 of the Limitation Act is also there.
Can you please main matter next week, anytime, madam?
If
Why
it is
should
not
you keep it
restored,
next week?
how can we call for it?
বসে আছে কোন বেঞ্চে দেখিয়ে what explanation you given huh? You are not
Cannot
present
be done mechanically. Give some explanation for us.
some explanation at least is required
Yes, madam.
or you don't want any explanation no explanation can be sought from you delay the restoration of line লিখেছে কি you are looking it at for the first time
Madam?
the application you are looking it for the first time or not
That application was for the first time.
Yes, madam. First application before the High Court.
what is your learned advocate was engaged in another upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are satisfied with the explanation given towards the delay in preferring the restoration application and the absence of the learned advocate of the petitioner before the court when the matter was dismissed for default on 3rd of January 2025. In view thereof, the delay in filing the restoration application is condoned and the order dated 3rd January 25 is recalled. Stop. The bail application being such and such is restored to its original filer number. Stop. The applications being granted such and such are disposed of. Stop. Next, list this matter. List the bail application for hearing. List the bail application in the daily supplementary list of this court on Wednesday. ওই দিন কি বলে ওই দিন কি গলা কেটে be happy for 3 days And don't take mark করে রাখো তো বল দিয়ে ever take adjournment we will see mark করে রাখবে yes next
Item number 50 same forum, my lord.
same order করে দাও restoration is there section 5 is there
No,
there was a delay
no, there is not. It is within period.
দাও that একটা গোটা ক্রেন আচ্ছা আগেরটাতে কাটতি যেটা করলাম সেটা দুটো অ্যাপ্লিকেশন ছিল হ্যাঁ ওয়ান অ্যান্ড টু এবার হচ্ছে ক্র্যান ওয়ান নন অ্যাপ্লিকেশন নন কবে 3rd January when did he file so there is a delay you have filed on 10th of February
10th of February.
file a CRAN. The learned advocate appearing for the petitioner prays for an accommodation to take appropriate steps. In view thereof, this the matter for further consideration on
Monday.
Monday. Can you file the application?
I can file.
Those need to file. And this is to 3 4-5 দিনের ডিলে হচ্ছে please the matter for further consideration on Tuesday করে দাও and give a copy to you. Who is your other side? Mr. Chakraborty was there.
Mr. Chakraborty.
Where is he?
Huh? I will sir.
কে কে আছে কে ওই আগের সময়টা কে ছিল
Mr. Chakraborty ছিলেন sir.
He was oh you did not serve that.
No,
Where
no,
is
yes,
he?
not.
He was just now.
We cannot proceed with that. First we have to serve the PP, then only.
Yes, next.
Get to.
My lord, I'm for the appellate.
Before my learned friend starts the argument, in the last occasion, my lord, we find an order sheet passed by the honorable coordinate bench where this application was argued at length and then withdrawn, dismissed and withdrawn. Honorable Provisional bench has directed for preparation of paper. The order is very clear.
What was dismissed as withdrawn?
Same petition.
It's a new petition filed.
Now he has filed a new petition. The order was, my lord, after arguing sometime, learned lawyer for the appellant seeks to withdraw the application for suspension of sentence. Accordingly, application for suspension of sentence is dismissed as withdrawn. Trial court records me
What was the date of the order?
29/1/2024.
29
1.
January 2025.
24. 29 January.
Yes, Mr. Shantanu.
Yes, my lord.
My lord, just I'll finish, my lord. Paper books be prepared for 4 weeks thereafter. Learned registrar shall communicate this order to the trial court for compliance. So this honorable court had already framed it by the appeal will be heard in 1 room. I fail to understand why this application is coming.
I would like to answer that.
Have you given a copy to him?
Yes, my lord.
Yes,
That's why he is appealing.
tell us why you want
My lord, page 5, para 6.
of the application.
Yes, my lord, my application, grand application. The matter came up for hearing on first, my lord, on 21st of January 2025. There was change of brief. I informed the court that there is a change of brief. I have to collect the paper. So the next date was fixed on 29th of January 2025. In the meanwhile, my lord, on 22nd of January 2025, after going through the brief, I found that many papers are missing. The depositions, the judgment copy were missing.
So you could have told the court
Yes,
that I
my
will file a supplement.
Yes, my lord, I have already, my lord will find annexer P4, the counterpart that I have applied and the endorsement by the department that they could not provide the copy as the file was lying before the court, this honorable court. So on the date of hearing, my lord, I prayed for adjournment, my lord. But since the I was engaged in another, I was on leg before court number 2, and my junior paid for time. My lord, the order was already passed. Thereafter, my lord, it was recalled, and I submitted clearly that I don't have papers. And if my lord records that without papers I have submitted, then I have no objection. So he asked me to either withdraw or to continue. I said that I will withdraw. So this was the order passed. Fairly submitting, my lord, I have, that's why I have mentioned in paragraph 6 of my application, entire story. And moreover, my lord, there was not rejection. It was not rejection. There might be a direction for paper books, but has the paper books be prepared? Anything? No, my lord. Moreover, my lord, I have a merit in this case. I will, if my lord allows me, then I can present it. Para 6, I have, that's why I have annexed with a separate, if my lord sees the annexer also, it is the department endorsement. On 21st, change of brief, on 22nd only I have applied.
You applied for what?
The certified copies of the depositions and everything, my lord. Deposition, the judgment copy. Even the the appeal was not, appeal copy was also not provided to me. The appeal copy was also not provided to me.
Grand dismissed.
Grand one was dismissed.
And dismissed as withdrawn.
Mr. Shantanu, you have withdrawn it. How can you file afresh?
My lord, since
You
I was,
can prefer expediting the appeal hearing.
my lord, the grand was withdrawn
Show
because
us show us any authority that having withdrawn a matter, I can file on the self-same cause of action. We understand your difficulty, but why we cannot sit in appeal over the, we cannot sit in appeal over the coordinate bench order, no? This is the problem.
But since a considerable time has passed, my lord, thereafter I filed it, my lord, after getting the documents.
You may have filed, but you have withdrawn your application for bail in connection with appeal. After recording such withdrawal, court has admitted the appeal. Show us any authority, we will be with you. Having withdrawn, sir, you cannot turn back and say, I will again come. Then the litigation will never remain. You are inviting us to the merit of the bail application. But having withdrawn, কি করে করবেন?
Lord, I clearly submitted before the honorable court.
That you ought to have insisted upon the court respectfully that if that is withdrawn is there, my lord, I would be prejudiced. Maybe your junior did not say that.
No, my lord, that I.
What is the allegation against it?
My lord, the NDPS.
NDPS?
Yes,
How much recovery?
My lord, recovery is huge, my lord, but they could not prove the case before the trial judge. Because the the three independent witness on whose testimony the case was standing, they have become hostile.
Have you prepared the paper book?
No, my lord. Paper book has not been yet prepared.
So show us any authority that having, you are the same advocate. Show us any authority that then you have to go before that coordinate bench. Anyway, we are sitting in that chair. Had it been, you after arguing for some time, Mr. such a learned lawyer appearing the appellant seeks to withdraw. Court grants that permission and dismisses.
Lord, I had no other choice to, because I had no papers, the deposition on which the entire case stands. I didn't have the copy. I could not place it before the court. That this deposition has to be stayed.
That can be done. Paper book could be submitted and the matter will be heard.
You submit the paper, we'll hear out the appeal.
But the paper book is will be prepared by the department. So until they prepared.
Then you show us any authority. We are not dismissing.
Keep it on Monday. I will.
Next Tuesday. Next Thursday.
Maybe prisoner to direct the ASP to get the paper.
We are not saying that. He will show us that having withdrawn, he can again make that. Yes, next. Yes. Some kind of order. In course of hearing, an adjournment has been paid for on behalf of the appellant.
Convict appellant.
Convict appellant. One appellant, Mr. Shanti.
Yes, my lord, one. No, two appellants.
Convicts appellants.
Appellant.
Both are convicts.
My lord.
To avail necessary instruction. Mr. Mojumdar, DS, বলে দেবে, learned, enters appearance on behalf of the Union of India.
My lord.
Leaves the matter for further consideration before the next available circuit court.
My lord.
My lord said on Thursday.
Go to the next.
My lord, kindly, Thursday, my lord, kindly, my lord.
Go to the next page, Mr. Shantanu. Get it on 3rd March. Mention anything. Yes, next.
My lord, I am for the appellant, my lord. The state of West Bengal is the appellant in this matter, my lord, in which, my lord, an order of acquittal has been challenged by the state before this honorable court. My lord, since it was an order of acquittal, my lord, we have preferred an application for leave to prefer this appeal. Such application was allowed and leave was granted, my lord, on 18th of January.
Who sought for leave?
My lord, the state sought for leave.
That leave was granted.
Granted, yes.
So now then it will be admitted.
Yes, yes. Usual order.
Which একটা order আছে দেখো, admitted, call for records, 4 weeks. But no one is there for the state. You are for the state.
I am for this state, my lord.
Oh,
State has-
you are for this.
Yes.
So তাহলে দেখি ফাইলটা একটু দেখো।
What is the section, relevant section of the appeal by the state?
397.
411, 414, 468 and 471 of the IPC.
New code, new code for 11 too.
Oh,
Right.
no, my lord,
There is a provision for preparing of the appeal on behalf of the state. What is the provision? Against the acquittal. What is the?
against acquittal, my lord, the leave has to be leave.
What is the section?
378 of the CRPC, sorry, BNSS, my lord, I have to check.
I'm asking for BNS.
419 1B of the BNSS.
Where is that order granting leave?
Lordship, it is annexed, my lord. My lord, certified copy is annexed.
Records reveal that having perused the grounds made in the application for leave to appeal, a coordinate bench of this court granted leave to the appellant to preferred appeal against the judgment and order dated 18 November 23 passed by the learned additional district and sessions judge, Karshiong, Darjeeling. Dr. Chaudhuri, learned advocate, appears on behalf of the heard Mr. Chaudhuri, learned advocate, appearing for the appellant. Stop. Next, the appeal is admitted. Stop. Call for the records. Stop. Issue usual notices. Stop. Paper books be prepared within 4 weeks from the date of receipt of the lower court records.
Trial court record.
Trial court records. এখন lower court বলে না।
I'm grateful to you, Lord. Now.
Lordship, in this matter, although it's coming under criminal admission of criminal appeal, it's a bail matter. The petitioner is appellant is suffering in custody since 4 years and 6 months. But Lordship, however, a service to the NIA has not been completed yet. It's still on the way. So if your Lordship may fix it for Monday.
I am appearing for the National Investigation Agency, Lord. We have not received any instructions.
Lordship.
Not you received the copy.
Not received the copy also.
Your
Lordship,
Lordship,
we can provide them today.
Your Lordship, I'm representing National Investigation Agency
as a special public prosecutor.
Yes.
At present, I'm in Delhi and recuperating by severe back pain, and I've been advised to not to travel. So I would submit let this case be posted on 6th or 7th of March. Due to
Lordship,
my
the petitioner is suffering since a long time, your lordship. Kindly fix it for Monday, your lordship.
actually, I would like to be physically present and argue the case.
Lordship, you are
And
seeking
due
the
to
bail
my
on parity, on the ground
due
of
to
parity.
due to my
The
health
co-accused have
condition,
been granted bail.
I've been
See,
advised
madam,
against traveling.
You have spent 4 years, spent 2 weeks. When he's sick, he says, I am sick, I believe.
6th or 7th of March, Your Lordship.
ওর নামটা কি বলো? What's your name?
Khushi Kundu.
যে ওই ফাইলটা দাও তো, এটা বেল অ্যাপ্লিকেশন।
Lordship, there are
Bail
two
in
matters.
connection with appeal. Bail in connection with appeal.
Lordship,
Feel under NIA.
two
Oh,
crimes are there.
So two grounds are there. One is for limitation.
Actually, against the bail rejection, an appeal is provided for under NIA
Miss
Act.
such a learned advocate appearing for the appearing for the appellant, prays for an accommodation to complete service of the applications being Tran 1 of 2025 and Tran 2 of 2025 upon the respondents. Stop. Do you have copies? Do you have copies of this?
Yes, your lordship, we have.
Mr. Agarwal,
Sir.
the advocate enters appearance today on behalf of the on behalf of the National Investigation Agency. Stop. The Miss Sajjan is directed to serve copies of the applications upon the learned advocate on record of the respondent within a week.
Today itself, lordship, it is.
Within a week, stop. List the matter for further consideration.
On 6th or 7th of March, Your Lordship.
Before the next available circuit bench. Yes.
Grateful, Your Honor.
Do they have to file delay of how many days?
It's 30 to 35 days.
You're opposing the delay?
Definitely, Your Lordship.
There is a Supreme Court judgment right now. Previously, there was a
Under section.
All right.
I'm grateful, my lord.
Next. এই লিস্টটাও তোমার দিয়ে দিলাম বোধ হয়, ভুল করো।
Your lordship, I am for the petitioner.
Item
54. Your lordship, I'm praying for time.
Why?
The advocate on record is out of station. Kindly fix on Tuesday, your lordship.
Mandamus appeal করবে না।
On Tuesday, your
ফাইলটা
lordship.
দাও। What is the matter about?
For appropriate order, your lordship.
Challenging that order, they have preferred this appeal.
The matter was heard on 12th November 2024. Disposing of your CAN application.
There was direction to file paperwork.
Now, why you have come up with another application?
For appropriate orders, your lordship.
For what appropriate order?
That's not in my knowledge, your lordship.
Have you
I've been-
served the copy upon him?
I-
To use an opposition? Have you got it, no?
Your lordship, kindly fix on Tuesday, your lordship.
Who is your advocate?
Arnav Shah.
Very good. We have given a copy. It will go to the next circuit. Records reveal that in connection with the present appeal, an application for appropriate orders being
Number 55, the conducting counsel in this matter, Mr. Kanoria, he is traveling. So if your lordship may keep it for Monday.
next Thursday.
Wait for a minute.
Or you go to the next bench. Unnecessary because
Lordship.
twice adjournment was given. Mr. Kanoria applied on, appeared before us online
Lordship,
yesterday.
today he is traveling at this moment.
Next circuit.
Lordship,
Next
kindly keep
circuit.
it next week. Lordship, I have specific instructions.
Next Thursday.
Grateful, Your Lordship.
The next matter, although I'm very embarrassed, my lord, at my instance, the matter has come up in the least, my lord. I'm led by Mr. Devashish Kundu. Since afternoon, my lord, he's currently feeling sick, my lord. So he couldn't join virtually, my lord. But if you look, he takes it on Monday, my lord.
Monday. An adjournment has been prayed for on behalf of the appellant, though Mr. Ghosh, learned advocate appearing for IOCL. IOCL is present. This is the matter for further consideration before the next available
Kindly, my lord,
Mr. Pal,
my license has been
these
terminated.
matters were called.
My lord, my license has been terminated, my lord. Kindly appreciate, my lord. My license for petrol pump has been terminated, my lord. My lord, kindly appreciate. I'm challenging the, my lord, kindly
Next
appreciate.
Thursday.
Grateful, lord. Okay.
It's the further consideration next
No,
Thursday.
My lord, can it be on Tuesday, my lord?
Sorry. Yes. You're tired of this. Yes. You as well.
My lord, the affidavit of service is not complete yet, my lord.
I
Kindly
state in this matter.
There are private respondents.
Firstly, sir, Lordship, I challenge the maintainability of this writ application.
This is not a writ petition, this is an appeal.
Madam, application. I take your point.
Who are the private respondents?
May I, Lordship?
Annesha Ghosh. 8, 9, 10 does not find in the cost title of the memo of appeal. 8, who were 8, 9 and 10? There are defects. Eight, 9, 10. Yes, you have happily left out 8, 9, 10. Huh? Where from did you get Annesha as an advocate, as a party? Huh?
My lord,
She was the party in writ petition. In the
no,
writ
she
petition.
was the petitioner in the writ petition.
She was the writ
Writ petitioner, my lord.
Now, appeal has been filed by whom?
Her
Rudraksh
father-in-law.
Ghosh.
Rudraksh Ghosh father had
No,
Lordship.
My lord, the appeal has been,
Rudraksh has been, he's the appellant now.
my lord.
So then why you have left out 8, 9 and 10?
8, 9, 10 is the father and mother of the.
So what? They will be pro forma respondents. Otherwise, they have to be appellants before us.
My lord,
either if they are your father and mother and not having any contrary claim, you
My
will
lord.
not be seeking any relief against them.
My lord.
So you have to implead them appropriately. That is the report of the stamp reporter.
My lord, then humbly seeking for liberty to
Lordship, one more
add them
submission.
as pro forma respondents.
One more submission, Lordship. The affidavit has been sworn by Mr. By the father without any authority of the son.
Why?
Father needs
It
the
is
authority.
effective. Previously, Mat 3 had been filed by the father. That had been rejected, dismissed on the grounds of maintainability. Now this mandamus application has been filed by the son who is being represented by his father without any appropriate authority.
The learned
So I challenge the maintainability of this.
Sir, let them remove the otherwise. Learned advocate appearing for the appellant prays for an accommodation to complete service upon the private respondent.
My lord.
And to remove the defects as pointed out by the learned additional stamp reporter. Learned take it up. Additional stamp. Mr. Your
Sumit Kumar.
Mr. Kumar, learned advocate, enters appearance on behalf of the respondent numbers 1 to 6.
Lordship. Lordship. 6.
Lease the matter for further consideration before the next available circuit bench. The petitioner is directed to remove the defects and complete service upon the private respondent in the meantime.
Lordship, it may be recorded that I have challenged the maintainability.
Defective appeal, the appeal has not been.
Lordship.
Private respondent থাকবে, বুঝেছো তো?
Grateful, your lordship.
My lord, I beg to appear on behalf of the petitioner appellant before your lordship.
Okay.
Lead by lordship.
My lord, I am sorry, my lord, I am appearing.
Who are you appearing
Lordship,
for?
my senior advocate is appearing virtually, Lordship. Usha Maitri.
For whom?
For petitioner, Lordship. Appellant.
What is this application about?
For coronation or delay of
129 days delay.
my lord.
129 days delay.
My lord, that is there.
Section 5 টা কি এখানে ডাউনি লিস্টে? Oh, there is a delay.
My lord, 129 days, my lord. I saw cause shown, my lord, on paragraph 3 to 6, my lordship.
Copy.
Yes.
Yes, my lord. Send all of the respondent has sent.
You want opposition? Want to oppose this?
Section 5, your lordship, as your lordship, please. I will not.
So you don't want to file any opposition to the section?
Just section 5.
Any other respondents are there?
But all of them.
You have served all of them.
Lordship, I have served all of them. The state is the answering respondent.
So you don't prepare any affidavit of service?
During the course of the day, I will file today only. If your lordship wants.
Next Thursday. Do it in the meantime.
It will not be taken up. Some urgency is there. Some urgency is there, your lordship.
Service is not complete, Miss Mike.
All of them have been sent, my lord. Only, my lord, one of the respondents, my lord, no return has come, my lord. That is why, my lord. No service
Yes,
return.
we have kept it next week.
On Monday.
No, not on Monday.
Your lordship, kindly, some urgency is there, but your lordship, kindly takes it up on Monday, my lord.
Monday you will get the service back.
Lordship,
How will you get it?
Today itself he is ready to, my lord. Today itself he is ready.
It's ready.
Tuesday করে দাও। Yes,
Tuesday I will not.
তাহলে Monday রাখো দেখো।
Grateful, Lordship.
Grateful, deeply obliged to your lordship.
Item number 59, lordship, I'm for the appealing, lordship.
My lord,
What's the Monday?
My lord, 59, I am for the respondent number 5, my lord.
Lordship, there is a restoration application, there is no delay, lordship. Within 15 days, I have filed the restoration, lordship.
My lord, I am for the respondent number 5. Dismissed in the year 2023, my lord, October.
And restoration has
23. Dismissed in 2023.
23.
October 2023.
Days,
October,
default.
Yes.
there is no delay, lordship. Within a 15
lord,
filed
on
the
application
it was running in the
Why
warning.
she is saying that there is no delay?
Application was affirmed on 13th October 2023.
and it was dismissed for default on 3rd.
Oh,
It came
before you, for your lordship's consideration much later, but the application was preferred.
Lordship,
The matter was running in the warning list on repeated occasion. They have not appeared.
Lordship, it was fully my fault, Lordship. I didn't recognize, Lordship.
And 2023 dismissed, my lord. 2025 today they are pressing the matter, my lord.
Several
And
location
there is no urgency. There is nothing, my lord. Kindly see the impugned order.
File your opposition then. When you are opposing the restoration, file your opposition.
Kindly fix a short date. Kindly restore it and file a short date of hearing, my lord. It may be disposed of.
The Mr. Ghosh, you are for whom?
Milord, I am for the primary board, Milord, 3 and 4.
And Mr. Mukherjee?
I am for the 5, my lord. Respondent number 5.
I'm for the appellate, Lordship.
School board, Darjeeling.
Miss Hard Miss
Ambia Khatun, Lordship.
Miss
Appellate.
Khatun, learned advocate appearing for the appellants. Mr. Ghosh, learned advocate appearing for the respondent number 3 and 4. And Mr. Mukherjee, learned advocate appearing for the respondent number 5. Pray for an accommodation, pray for leave to file an affidavit in opposition to the said restoration application. Let such affidavit in opposition be filed within 2 weeks. 2 weeks. Reply thereto, if any, be filed within a week thereafter. Release the matter before the next available 30 days.
Lordship, it was my fault. Matter was dismissed for default, Lordship. I could not follow the board, Lordship.
It is not the question of restoration. Why you have slept from 2023 to 2025?
There are several locations I have mentioned before the division based matter has not been listed.
Very good. When they are wanting to oppose that restoration, let them file their opposition. You have waited since 2023. Wait for 2 more.
Next circuit bench, Lordship. Grateful.
60, my lord. Mr. Withdrawal is appearing on virtual.
Malad, this matter,
what is
I am for the appellate.
There was direction for the college to file a report. Certain question was framed by your lordship that college has filed the reply.
You are for college?
No, I am for state college also. It is a state government college.
No, Malad, in this matter, I am to say, your lordship kindly see the order dated 22nd August 2024 passed by the coordinator. Please kindly look. This is my order. The direction upon the principal to file the affidavit to answer the questions, queries of the court through register. How can it be, the third with the state of advocate of state? I don't know, because they are denying appearing on behalf of the college each and every time. Or last, from the writ petition, they are saying that we are not grateful.
Yes, who is appearing for the college?
Today we are acting on behalf of the college.
You are appearing for
In
the
the
college.
college did not turn up.
So you are entering appearance
On
on.
behalf of the college.
So when the matter was heard on that 22nd August, anybody? No.
No.
Mr. Bormon appeared for this.
On behalf of state respondent. Since
So
it is a
court
government,
has-
since it is a government college.
Very good. But when the court has passed such an extensive order, your principal in charge does not think in fit to file an affidavit. And he will hand over an instruction like this. Huh?
Just hand it
So
over
you
to the-
call your principal in charge, he's such a busy person. Huh? Who is your principal in charge? Huh? We will appear, we will ask him to personally appear.
I did not follow the last order. We will file this in the form of a.
Last order was of 8 pages. Next order is of 3 pages. Still your
that's-
principal does not understand. Cannot accept this.
No, she will file it in the form of a.
Heard Mr. De Learned Advocate appearing for the appellant. No, Mr. De Learned Advocate appearing for the appellant submits that in terms of the last order passed by the coordinate bench on 5th November 2024, notice was served to the respondents. Due notice was served for the respondents. Stop. Today, Mr. Bormon, learned advocate, appearing for the Mr. Bormon, learned advocate, submits that he has instructions to appear on behalf of the state respondents as well as the as well as which one?
Respondents number 5, 6, ABN Steel College.
As well as the college authority.
College authority.
Being the respondent numbers
5
and
6.
as well as the college authority. he today he prays for extension of time. File the direction to file Mr. Bormoner আগে লিখবে records reveal that by an order dated 22nd August 2024, a coordinate bench of this court specifically directed the principal in charge of the concerned college to file a report by way of an affidavit answering the questions as formulated in the said order. Answering the questions as stated in the said order dated 22nd August 2024. Today, today Mr. Bormon appears on behalf of the state respondent as well as the and submits that he is appearing on behalf of the state respondents and has instructions to appear on also on behalf of the college authorities. So, he prays for an accommodation. He prays for an accommodation to comply with the order dated 22nd August 2024. He on behalf of the principal in charge of the said college prays for extension of time to comply with the said order dated, comply with the directions contained in the order dated 22nd August 2020. No reason is forthcoming as to why, though the order was passed way back on 22nd August 2024, the principal in charge of the concerned had not filed the affidavit as called for. In view thereof, as a last chance, time to file the affidavit as called for by the order dated 22nd August 2024 is extended till 4th March 2025. It is made clear that in the event no such affidavit is filed, this court may be constrained to direct the personal appearance of the principal in charge. List the matter for further consideration under the same heading in the daily supplementary list of this court on 4th March, subject to the convenience of the honorable certificates.
Malad, only one thing, Malad, may I say, Malad, if your lordship kindly direct them to start by an advance copy of that affidavit so that we can take an exception and the matter can be heard in
There
the
was,
next
court did not direct service of a copy. Court only directed that let him file an affidavit. Let him file that. If required, we will.
No, no, Malad. Malad, direction is that, Malad, paragraph 19 of that order.
Oh, acha.
Your lordship kindly come,
Yes.
paragraph 19.
আরেকটা প্যারা তার আছে in terms of the said order time to file কি বলেছো within
By the last source, time to file the affidavit as called for by the order dated 22nd August is extended till 4th March.
না তারপর লেখো is extended till 4th March. Comply with the directions বললে না
No reason is forthcoming.
হ্যাঁ তারপর
Forthcoming has to find that the order that though the order was passed way back on 22nd August, the principal in charge of the concerned college had not affidavit as called for. In view thereof, as the last chance, time to file the
না in view thereof as a last chance, the principal of the said college being the respondent number
5 and 6.
আবার 5 and 6 কি করে হবে প্রিন্সিপাল will
Malad,
be
respondent
person.
5 and 6.
Respondent number 6.
5 is the college and 6 is the principal.
6 করে দাও Principal has been asked to file. Directed to. না ওটা কেটে দাও তার আগের লাইনটা কি করলে has not no explanation is forthcoming as a last chance as a last chance the principal of the said college is directed to file such affidavit by 4th March 2025 with an advance copy to the learned advocate appearing for the appellant. An advance, oh no, advance copy. Registry of the bench will serve.
Malad, may I explain? Only explain the matter, Malad. Malad, since no one appears for the college, Malad, since my learned friend.
Achha, why you are saying
to,
advance copy has to be given by them to you? Have you read the order? You stopped us from dictating. Paragraph 19, what is written in that?
An advance copy of the report be made available to the learned counsel for the appellant and the state by the registry of the circuit.
So the registry will send it to you.
Because Malad, they have to, Malad, the principal has to deposit it, Malad, Malad, paragraph 18 said principal has to submit the report affidavit before the registry. That's why.
So এটা কেটে দাও, as directed by the, as directed earlier, the principal, the principal of the said college shall be made. As a last chance, time to file the report is extended till 4th করেছো তো না 4th করেছো you have to file it in the department then.
Since at the time of order, since we were not appearing, so direction was given.
Answering that, কোথায় ফাইল করবে বললো না বলে বললো it is expected. No explanation as to why no such report has been filed বলেছো তো তারপরে লেখো on the prayer of Mr. Bormon and as a last chance the time to file such affidavit with the registrar of the circuit bench is extended till 4th. Stop. Upon filing of such affidavit, the registry of the circuit bench shall
copy of the report made available to counsel for the appeal. And state by the state by the registry circuit upon receipt of the same. মনে হচ্ছে না
অ্যাডভান্স কপি করতে আসবে কিন্তু বলেই দিল রেজিস্টারের কাছে ফাইল করবে
register the first time receipt of the order. Advance copy of this report be made available to the learned counsel appellant
and the state advance copy করতে and the registry shall make available the said affidavit to the learned advocate on record of the appellant within 7th March. Lease the matter for consideration under the same heading daily supplementary list of this court on 10th March, subject to the convenience of. You have to file it in the registry. Affidavit along with the report. And the registry, you have to tell the registry that ensure service upon the. You also keep contact.
61, 62, 60, 61. Okay, 60, 61. Next time is same. 60 and 61.
Same report.
Same.
কোথায়? Hey, Mr. Bormol, next matter also you are appearing.
Same. In both cases,
Same order was passed.
same order.
দেখেছো তো? That same direction was there. তা তুমি
Yes, madam.
তুমি পাঠিয়ে দিও ওটা দেখে
Same
পরেরটা
college,
তুমি
same.
7 সেম কলেজ গিয়ে দিয়ে ওটাকে পেস্ট করে ইয়েতে পাঠিয়ে দিই কেন তো কি বললাম আমি ইয়েস ওই আইটেমটা কল করে দাও 60 হ্যাঁ 61 কল করেছে ইয়েস
61 also.
আইটেম নাম্বার
47.
40
Senior counsel, Learned Advocate, Senior Advocate, Kalyan Sarkar is appearing virtually.
I'm for the respondent.
Yes, Mr.
My lords, as your lordship has indicated the other day, my lords have heard the matter at length. But still, my lord, just to give us.
Yes, yes. No, no,
My lord,
Mr. He assisted us, but he said that you would be arguing. Yes, but
I hope, my lord, my assistance be of some worth. My lord, we have.
that cannot be guaranteed. We can go against you also.
No, not in that sense, my lord. At least I may be of help to the court. My lord may decide this way or that way. Well, we have jotted down a list of dates.
Yes.
So, my lord, what happened?
They have a copy to your friend. Yes, Mr.
No, my lord, what happened? A certain advertisement was published by the government for appointment of Gram Dark Sevaks. And so-called appointment process was proceeded with. And a certain person was appointed to the post. Now, the person who was appointed to the post happens to be the respondent, Pritham Vishwas. Subsequent to his appointment, my lord, there were certain complaints made and a vigilance took over. When the vigilance submitted his report, it came to light, the entire process was illegal. Not only from the beginning of not properly advertising, not properly following the procedure of advertisement and interview, the person who was given job was not in the merit matlab. He was not just next in the merit.
He was the third person.
Third person. So the gross and flagrant violation of all known norms of appointment.
So an order of termination
was issued.
In
A
respect
show cause
of
was issued. Pritham Vishwas was given a show cause and he was terminated. Now, my lord, here
there was an initial order of termination.
This is the first order.
No. There was a order of termination initially on 17th May 2016.
On 16/5/2016, the vigilance.
Have you incorporated the vigilance report here?
Yes, madam.
That is in which page, Mr. Mojumdar?
Just give me once. Well, it starts from 104.
Yes.
96 onwards, my lord. 96, 97 onwards.
97 onwards.
First termination order, first
The investigation report in connection with recruitment of various GDS Gramin Dark Server posts of doers served DN made by Sri Sanjay Bhattacharya. Page 97. Yes. So this Sanjay Bhattacharya was the person who violated every known norms of appointment. And against him, a vigilance inquiry was done and he was found guilty. And the entire process was found to be illegal. This is the vigilance report, Lordship. 97. Onwards. 97 to 111, 12. 114. 14, my lord. Acha, 97 to 114. Yes, sir. So 17/5/2016, after the vigilance report dated 16/5/2016 came in, the on the very next date, he was terminated under Section 8 of the GDS Conduct and Engagement Rules of 2011. So this selection process, open advertisement for press service, or they were already there? No, they were fresh service. But why it is being said that this selection shall be would have been treated as irregular as it was not routed through the selection and was liable to be cancelled? If this recruitment was investigated earlier, this irregularity, selected candidate would not get any scope for qualifying in department examination. My lord, because when the vigilance took over subsequently, after the appointment was already given to him. Appointment was given on which date? Appointment was given to him on 2013. 2013. Now, vigilance started from 2016 and submitted its reports in within a month. On 16/5/2016, the vigilance report came in, and on 17/5/2016, the authorities terminated Pritam Biswas under Section 8(2) of the Gramin Dakshar rules. No, I am wanting to know why it is said that would not get any scope for qualifying to department for promotion. Going back, vigilance is referring to a date that had already taken place. Vigilance is referring to a matter of 2013. No, promotion. My lord, which page does your lordship refer to? Where from this promotion what come? My lord, give me 1 second. Who are the two persons? Pritam Biswas, one person. That's one person. Actually, my lord, there were certain irregularities that were noticed by the vigilance that has been jotted down with the vigilance in page 99, if your lordship pleases to take it. Surprisingly, a little bit of time had been taken between submission of workload for permission or for equipment and giving permission. Same is the case happened in the case of issuance of notifications. Individual recruitment file was not maintained. No, very good, Mr. Mujumdar. After this, what happened? Where is the order of termination? Lordship order of termination, first termination order. I think page 47, no? Page 99. No. 29. 29, my lord, 29. 29. 17/5/2016 was the termination order under 8(2) of the GDS conduct. Yes. This is page 20. This is page 29. Page 29, lordship. Yes. Now challenging this event before the tribunal. Now tribunal passed an order on 2nd September 2006 upholding the order of termination. Lordship. No, lordship. Tribunal said
Because he has not completed 3 years of service.
Where is the next last page of the tribunal order? We
That's
told
it.
you that.
Yes, we have got it. We have collected.
What is this you're showing?
My lord, the sections.
Acha, acha. Where is the last page?
My lord, I have collected the entire order. My lord, to find the last page.
Acha. Yeah, no, please read now, Mr. Singhania, you, Mr. Mojumdar, para 24. Give us one copy, that will do.
My lord, para 24 is
Conclusion.
conclusion. In view of the above mentioned facts and circumstances, we left with no option to set aside the order of termination of engagement dated 65/2016. However, it be open to the respondents that if they want to proceed to disengage the applicants, they could do so by adopting the procedure prescribed under the aforesaid rules of 2011. We also make it clear while delivering the judgment, we simply discuss the legal aspect of the matter and have not make any comment on the merit of the case. The respondent authorities will be free to take any decision without being influenced by this order, so far as the merit of the case is concerned. The relief sought for declaring Rule 8 of the aforesaid rules of 2011 as ultra vires, being violative of Article 14, 16, and 21 of the Constitution of India, is declined, and to that extent, all these AOs shall stand dismissed. With these observations, the AO numbers 769, 770, 771, 772, and 770 of 2016 are partly allowed, but with no cost. The interim order passed in these circumstances need no extension.
Yes. Now you issue a fresh show cause.
We issued a fresh show cause.
That is on 13 December, page 54.
Lots of.
Now they give a reply and ultimately you issue another fresh order.
Yes, Lord.
On 20th January 2017.
18.
So this order is page, we are coming to that. This order at page 58
Lordship.
is absolutely the same as the earlier order of termination, which is at page 29.
Lordship, only the difference is this charging section under which you were starting.
Right, charging section. So when they went up challenging that order of the tribunal before the High Court order, Mr. Mojumdar, please come.
Lordship.
That is at page 75.
Lordship.
Rather, if you come at page 76.
Lordship.
An identical issue arose in such and such, coordinate bench such and such, 20 as a offer. We put a query to Mr. Shomir Pal.
Yes, my lord. Learned advocate is pleading on behalf of Union of India regarding whether the period of engagement commencing from the date of set aside termination, 17th May 2016, to second termination on 2021-2017 would be a period of new service. If it is not, inevitable conclusion is that the petitioner is deemed to have been in continuous service. At this stage, Mr. Pal submits this issue be remanded to the tribunal. Mr. Mukherjee submits that be done. In view of the submissions made on behalf of the Union of India, we set aside the impugned order and restore the matter to the tribunal for it to consider the question on the point as recorded above. Pending adjudication of this question, petitioner will be entitled to apply for interim measures before the tribunal. We have heard the learned counsel for the parties. Learned counsels are at item that the issues involved in the present writ application is the same as the one that was involved in the earlier writ application mentioned above, and an order may be passed in this writ application following the order passed in the earlier writ application. In view of the above, we set aside the order impugned in this writ application and remand the matter to the learned tribunal for it to consider the issues between the parties afresh in the light of the order passed by this court on the earlier writ petition. Pending adjudication of the matter, the writ petitioner will be entitled to apply for interim relief before the learned tribunal.
No. So now please come, Mr. Mojumdar. if we can discuss with you, the first order of termination was 17th May 2016. His entry into service was in 2013. So Rule 8 can apply only when 3 years service is that Rule 8 has been quoted. Rule 8 says that you will find, Mr. Mojumdar, at
Lordship, the engagement of a sevak who has not already rendered more than 3 years continuous service from the date of his engagement
You are
shall be
reading-
liable to be terminated.
where you are reading.
So I am reading from the book, my lord.
Oh, book, sir.
Well, my lord, we have
That
given
has
the,
been
we have
quoted,
given the
quoted.
sections.
Rule 8. আর লাগবে না।
The engagement of a sevak who has not already rendered more than 3 years continuous service from the date of his
So you applied Rule 8 since he did not complete 3 years. And you considered and
Earlier we applied 4.
now earlier his entry into service was 14th August 2013.
Lordship.
His termination, you have terminated him prior to on
3 years.
3 years, as provided under Rule 8. You
8.
can do so.
Yes.
Tribunal said that Rule 8 order which you have passed, that is a not non-speaking order, and you should have given him an opportunity of hearing. So
Sure.
it was like a termination simpliciter.
According
Like-
to tribunal.
As you do, Mr. Mojumdar, when contractual engagement.
Yes, ma'am.
You say that if your service is not satisfactory, I will not continue with. But if it is stigmatic, you have to give him a notice. Good, bad, indifferent, tribunal thought that they ought to have been served with a notice before termination. So you served notice then.
Yes.
But in the meantime, High Court observed that if the termination order is set aside, termination of 17th May 2016,
Absolutely.
if it is set aside and he is appointed afresh, if he is appointed address, whether when you are passing the second order, you can apply Rule 8 again.
My lord.
This is the issue.
My lord, in the first order, that is when the first time his termination came into play, whether it is correct or not, I am not on that. First time tribunal entered into the dispute and passed an order saying that your application of the section dismissing is wrong.
Application?
Your application of the section under which you dismissed him is wrong.
Very good. That has now
But-
merged with the order of
My
the
lord,
High Court.
my lord, just BSP for a
Yes.
moment. Now, my lord, in the order dated tribunal's first order, he was not given any allowance as to get reinstated. The order does not say that you will be reinstated. And my lord knows that the tribunal cannot say that. Tribunal cannot order reinstatement. So that has been settled by the series of decisions of the Honorable Apex Court. My lord, once I can.
No. Then, Mr. Mojumdar, what is your argument to page 76?
Lordship.
High Court has framed the issue now.
Yes, but he did not only frame the issue, in light of the issues, you decided afresh.
What was the scope of consideration given to you? Page 76. Query was
whether he could be said
whether
to have
the
been
period of engagement commencing from the date of setting aside, that is 17th May, to the second termination on 2nd January 2017 would be a new service or not?
that if it is not a new service, he will be in continuous.
Yes.
Yes.
And then Rule 8 will not apply.
No, Rule 8 will not be applied, then Rule 4 will come.
So
But
you
one
should have-
thing, my lord, none of the appellate authority has said termination is bad. He ought to be terminated.
No, Mr. Mojumdar, when everything merges with the High Court order. Your
Yes.
argument is absolutely right. We appreciate that tribunal at the time of setting aside that same did not say you will be reinstated. Tribunal, on the contrary, said that you can proceed afresh.
Yes, ma'am.
But when the termination is set aside, whether there will be automatic reinstatement or not, as you are arguing. You are right, that if it's set aside whether it will be automatic reinstatement or not, there are thousands of judgments. But that, Mr. Majumdar, subject to correction, you cannot agitate now, since the High Court has limited the issue to this
No,
point.
my lord, Honorable High Court had said, Tribunal, you decide whether the service should be deemed to be continuous or not.
Now please come to the tribunal's finding.
My lord, let me once again read out. In view of the above, my lord, page 77.
77.
In view of the above, we set aside the order impugned in this writ application and
Which
remand.
was the order impugned?
Tribunal's order.
Tribunal
Second order
order
of the tribunal.
by which the
My lord, the first term, first
anyway,
termination.
we set aside the order impugned. Which is the order
Lordship, it
impugned?
is
That affirming the order of termination.
termination.
That is affirming the order of termination set aside, that you just now read, page 53 and 50, 52 and 53.
No, my lord, this is the 53 is the first one.
That is the first one, that you were.
No. Now, this High Court interfered in the second termination order.
Second order of page.
64, start from 64.
No, what was the subject matter of challenge in the tribunal order? Second tribunal,
termination.
that is at page 50.
No, my lord, it starts from 61.
No, page 63.
Yes, yes, my lord, page 63 starts from page 63, second order of the tribunal. Actually, it starts from 64, my lord.
No, the order of termination which they
It's 63.
challenged.
It's 63.
The 63
Yes, my lord.
order was a fresh order
Yes.
after granting show cause and reply
Yes.
in terms of the tribunal's earlier order.
Earlier order.
So this order of termination of 2017 was challenged.
Yes.
Now High Court said that you have to answer the point whether the termination which was initially set aside on 17th May 2016 and the new termination ordered in 28th January 2017, whether 28th January 27 will be a new termination, and then what will happen to the earlier period.
Now, that question was to be dealt with by the tribunal.
Now tribunal, what the tribunal has said, Mr.
But
Majumdar.
one thing, my lord, if
That has been decided by the time.
in view of that, my lord, please come once again, takes place 77. In view of the above, we set aside the order impugned in this writ application and remand the matter to the learned tribunal for it to consider the issues between the parties afresh.
What is the issue? Whether the period of engagement commencing from the date of first termination to second termination on Ato would be a period of new service.
My lord, we will find the issues in the order of the tribunal.
Yes.
My lord, please take place 66.
That is the earlier.
My lord, page 67, paragraph 5.
Page
67.
60. Yes.
The primary issue is to be decided here is whether the respondents had followed the procedure and laid down in Gram Dakshebak conduct of engagement rules of 2011 terminating the engagement of the applicant. At the outset, we record the provisional engagement appointment of the applicant dated so and so. My lord, may very well skip this. Upon setting aside of the termination order in the first stage of the litigation, the respondent will given liberty to disengage the applicant by adopting the procedure prescribed.
Right, that is rule 4.
No, my lord. Liberty.
That was, wait, yes.
Liberty was given to the department to decide whether he will continue or discontinue. Otherwise, the learned tribunal would have been very specific, saying that you take him back, give him the back wages, right or wrong. Now that could have been a point of challenge, that in view of the law settled by the Honorable Apex Court, tribunal couldn't have given the order of reinstatement.
But the tribunal did reinstate.
No, in the first order did not.
Your
Second order it has done, and we are challenging them.
no, second order is
Third
of
order.
2017.
No, madam, third order, we are challenging the third order.
No.
After
First-
remand, after remand, tribunal gave a finding.
Right.
Now we are challenging that.
Yes, we understand. But this, let us come to the first order of the tribunal by which your order at page 29 was set aside. That is at page 53,
Lordship.
which you just now read before us. So it was said that we are setting aside the termination. Once the tribunal
Yes, my lord.
sets aside the termination, and then he is automatically
No,
reinstated.
my lord, the tribunal did not say that.
Yes.
My lord, let us-
Tribunal did not say that. That was sent for consideration.
we did not take him back.
That is the order you are challenging now, na? Because the tribunal has said that for the period from first termination to second termination, that period, whether it will be new service or not, please decide. Tribunal said that it cannot be a new service. It is a continuation of service. As such, the order which you have passed under Rule 8(1) again is a wrong. Correct us if you are wrong.
No, my lord, that is the analogy.
That is the argument.
Because
So what is your argument?
Tribunal, rightly, wrongly, whatever good bad neutral founding has been given, that his appointment is continuous. Because the tribunal is of the opinion that since the interim orders that were passed of termination, either by the tribe set aside, either by the tribunal or by the High Court.
Due to since, sorry.
The interim termination orders that were passed upon the particular petitioner, who is now the respondent, were set aside either by the tribunal or by the High Court. So, tribunal went under the impression that since the order were nullified, so he is continuing. Yes, that is a layman's idea. Since it is not there, it cannot be here.
So what is your argument?
No, my lord, nowhere in the first order tribunal had said you go back, your service has been given back.
Nowhere in the first order
of the tribunal set aside our termination on the ground of wrong section of law.
Yes, please come to that later. First argument you are saying is nowhere in the first order it is said
that you are
reinstated.
You are reinstated.
Yes.
Rather, a liberty was given to the department to throw him out of service by adopting proper procedure of law.
Yes.
I think my lord Justice Vishwas is mind is there is some query.
No, please continue.
Now, my lord, then department is on disengaging him because the whole process was illegal.
Yes.
Now we again serve him with a notice because now the section had to be changed in the direction of the tribunal. Section was changed, notice was given, he was terminated.
No, section was not changed.
My lord,
Because
4 and 2, 4 and 8.
Yes, Shokas was under 4. Page 86. Where did you say that it is? Had it been under 4, you would not have terminated under 8. 4 will apply to a person
who has not completed 3 years.
No, that 8 will apply in respect of persons who have not completed 3 years.
Now, tribunal said, since it was of the opinion that he has, according to tribunal, 8 would not apply, 4 would apply. First termination was under Rule 4.
No. First termination was under Rule 8, page 29. All right, Mr. Mujumdar, you summarize your arguments. First was in the first order, though set aside, there was no direction
No
towards
enhancement.
termination. On the contrary, they have given us liberty to proceed afresh for disengagement. So the question of continuity of service cannot
It
arise.
was neither in the mind of the tribunal. When the tribunal set aside the order on technical ground, tribunal never intended that the applicant should get back his service.
Yes.
What was not intended at that point of time cannot be inferred now. Now, second show cause was given, he was terminated.
Yes.
But where we are getting astray is whenever using the term terminated, because it was only correction of his termination, if I'm permitted to submit. Because till then, my lord, he was not taken back into service.
No, he was not allowed to join.
No.
Huh. After the tribunals. No, first
No, no.
termination which was set aside, thereafter you allowed him to join. How can you issue show cause then?
Yes.
After first order reinstated.
চ্যালেঞ্জ করলাম সেখানেও লাস্ট ট্রাইব্যুনাল আমাদের আবার থেকে বললো লিবার্টি টু অ্যাকর্ডিং টু ল।
Where is that you were reinstated? After the tribunal's order, were you reinstated?
So I was reinstated. Thereafter, the focus was been.
I understand, but is there any document that you have been
There's
reinstated?
documents, Lordship.
Have you worked from the date of after setting aside of the first termination?
Lordship. Thereafter, I was been taken.
What you are saying, Mr. Shortcut, have you worked?
Yes, my lord, he was working in the department.
Show us the paragraph where you have stated that.
It's a repetition by them.
Oh, so you will not get any copy there from?
Petition by her.
That is not in dispute, I think. They were Mr. Singhania on the last date said that after this they have been reinstated.
Admitted.
All right, Mr. Mujumdar, anything
what
else you want to point out?
Anyway, go for the
It's communist.
আমার কি টার্মিনেশন ডিসচার্জ করা সার্ভিসটা উড়িয়ে যাবে আফটার রিইনস্টেটমেন্ট ট্রাইব্যুনাল সেই জন্য ঠিকই বলেছে
সেটা যেতে পারে না।
যেতে পারে না যদি না যেতে পেরে থাকে তুমি আমার রুল 8(1) এ ডিসমিস করতে পারো the sum and substance of the tribunal's order if as you have argued is that once you have terminated in 2015, the termination when set aside by the tribunal, you cannot say that that period of service cannot be taken into consideration while you are issuing the fresh order of termination after show cause. To that your answer is, so what did the tribunal say? That your procedure which you have accepted, you should have counted his service, you ought to have treated him as a regular employee, then you could have treated him as disciplinary proceeding for setting aside his engagement. That you could have adopted.
My lord, we initially had given him section 4 notice.
Where is that? Sure.
Bhai, তুমি তো চুপ করো না।
Please take your seat. Please take your seat. Let Mr. Mujumdar
তুমি
complete.
বলো দাও সিনিয়রকে বলতো।
Yes. Where is that, Mr. Mujumdar?
Lordship, sorry, I stand corrected. It was under 8(2). Because we counted
less than
3. Now, tribunal said 8(2) is bad, you go under 4.
tribunal did not exactly
No,
mention this.
tribunal did not give us any provision, but there was only two provisions of termination. One is 8 and one is 4. Now 4 says, may I read it or not?
Yes.
The recruiting authority in respect of each category of sevok shall be as shown in the scheduled annex here. In any doubt arises as to who is the appropriate authority, in any case, the matter shall be referred to the government whose decision thereon shall be final. Notwithstanding anything contained in these rules, any authority superior to the recruiting authority as shown in the schedule may at any time, either on its own motion or otherwise, call for the records relating to engagement of grabbing dark box made by the recruiting authority, and if such recruiting authority appears to have exercised jurisdiction not vested in it by law or rules time being in force, or to have failed to exercise a jurisdiction so vested, or to have acted in exercise of jurisdiction illegally or with material irregularity, such superior authority may, after giving an opportunity of being heard, make such order as it thinks fit. So section 4 is much wider than.
Yes.
No, this, my lord, in a way is not on the volition of the department, but as indirectly prompted by the tribunal.
So who stopped you from passing an order under section 4? You again passed under rule 8. That is the wrong which has been done. How can you rectify that, Mr. Muli?
Yeah, but it is.
This, if this goes, now the question is, if this goes, suppose if we dismiss your writ petition, then what is the fact scenario? Will you be debarred from initiating proceedings against me for?
No, that will not be the fact. But my lord, one thing that the tribunal has done very seriously gone astray is directing order of reinstatement. That was beyond the purview of the tribunal.
Where do you see? On the contrary, tribunal gave you leave. It is quashed with liberty to act in accordance with law. Kindly come to page 84.
Judicial or quasi-judicial authority will say that, act in law.
Page 84.
My lord, please see. No.
What mistake you committed was you issued the next order of termination under
Same
Rule
section.
4. Rule
My
8.
lord.
You will not be prejudiced, Mr. Molinda. In view of such,
having noted that upon his reinstatement, his past service could be counted towards his later service, the termination order issued
under a wrong provision.
So here the tribunal said you reinstate him.
Yes, that is natural.
That tribunal cannot say.
Why?
My lord, I could not bring the judgment. Supreme Court has said you can, tribunal cannot, not even the honorable court.
All right.
Now, my lord, virtually this writ is a judicial review over the administrative process that was taken by the authority while dismissing a gram tax above.
All right.
Now, my lord, this court will only look into the process where there may be a palpable wrong. Maybe, or may not.
Then the entire exercise becomes a nullity.
No, my lord.
Suppose tribunal says that I am setting aside your termination, then what? They will be in error.
No, my lord. I'm coming to that. The authority
tribunal will not say that when we have set aside the
my lord, the
termination.
tribunal will say you went wrong from point A, start from wrong.
That has been said with liberty given to you.
But he cannot say you reinstate. Then, my lord, allow me till Monday, I will supply you the judgment. My lord, that the apex court is. My lord, let me supply the judgment. Your lordship will read the judgment. In spite of that, your lordship finds that the tribunal has the authority to reinstate. My lord, we will be sent back again.
No, Mr. Mujumdar, I think you are not, I am not being clear to you. I am saying that good, bad, indifferent, a termination order has been set aside with liberty to you to act in accordance with law. Today, what you can, subject to correction, what you can interpretation of this order, you have challenged this. You have challenged this. You are saying that I shall not reinstate you.
No, my lord, I am saying
when your termination
have ordered reinstatement.
No, Mr. Mujumdar, if the termination order is set aside, what will any person understand?
My
that
lord,
I will not be reinstated.
No, my lord. Absolutely not.
Then what is to be?
Honorable Apex Court has said, you cannot order.
So please give us the.
But right now I don't, I will Monday will supply it.
Yes, Mr. Sarkar, do you have to?
My lord, in the first order of the High Court,
Yes.
of the Honorable High Court, they did not challenge in any way. First order, if they agreed, that has not been challenged by the respondents.
No, Mr. Mojumdar is not arguing that. Mr. Mojumdar is saying that due to a quotation of a wrong section, like nomenclature does not matter. What matters is the fact of it.
My lord, your lordship has already hold that the respondents, my lord, when they have decided, the Honorable Tribunal has said the termination has been set aside. Naturally, it will be natural justice. The person will be in the employment, and my lord, he was employed. He was given work.
When? After the tribunal's order?
After the tribunal's order.
He was allowed to join.
Join.
Yes. Anything else you want to say?
No, my lord. Your lordship extensively heard the matter.
Yes, now,
My lord, only
Mr. Mojumdar, which judgment you are relying?
Right, I don't have the citation. Monday, my lord, I will give him a copy and file.
Very good.
Where
The-
specifically, my lord, I am very frankly confessing, when I first came against those 3-4 judgments of the Honorable Court, I also got confused that what will happen to the delinquent. If the Honorable Court says that to apex court of the country, that fine, you have found fault in the procedure, you ask the authority to start afresh from that point, but you cannot say reappoint.
Show us the judgment.
Lordship.
We have extensively heard Mr. Mojumdar, learned DSP, appearing for the petitioners. And
My lord,
Mr.
if
Sarkar,
your lordship allows me, I will just give you a short synopsis.
as fast as you can give, we can pass
My
the
lord, on
order.
Monday, whenever your lordship wants.
You tell us when it will be convenient. We
My
will.
lord, this court is always busy.
No. Achha, we have extensively
indicate the time, I will
heard Mr. Mojumdar, learned DSP, appearing for the petitioners, and Mr. Kullan Sarkar, learned advocate, appearing for the respondent. Stop. In view thereof, list the matter as for orders in the daily supplementary list of this court on Monday as fixed at 4 p.m. or as fixed at 3:30 p.m. You give us the judgment.
I'm grateful.
No. Why? We are still learning. That is why you people are there. You will point out to us that what is the mistake, what is the. And this is we are just interacting with you.
My lord, before my lord rises,
my
lord, my lord, I'm on the virtual mode. My lord, may I have my lord's kind leave to mention item number 94, a hearing matter. 94 of my lord's
on
list.
Monday we will.
No, my lord, I was praying for next circuit, but I had some difficulty next week.
Tell your junior when it is called, he will remind us. If it is reached, we will adjourn it then.
Very well, very well.